Good morning. Welcome everyone to the BSC's first Tokyo Summit. I think it is the first one. I'm delighted to be here today as the chairman of the Japan Institute for International Arbitration Research and Training, a proud co-sponsor of this summit. Please allow me to start by telling you a little bit about our institute, shortened GERT. GERT, like BSC, is a member of the Asian Pacific Regional Arbitration Group. GERT's mission is to conduct research and provide education and training on the practice of international arbitration. GERT's board members come from the field of private practice as well as academia and brings a wealth of legal knowledge and experience a lot. In line with our international focus, GERT also has an advisory board of prominent arbitration professionals from around the world. Our board members and advisors allow GERT to share insight into international arbitration with a broad audience, from young lawyers, researchers, in-house counsel, to university students. Our aim is to provide opportunities for young people to play an active role in international arbitration. We at GERT look forward to working with BSC more closely in the near future as a close partner towards our shared goal of promoting international arbitration in Asia. It is my hope that this will lead to close cooperation between China and Japan in this regard as well. Since Japan is a host country for today's summit, I'd like to take the next few moments to speak to you about the progress that Japan has seen in the practice of international arbitration. I don't duplicate Mr. Kitagawa's. A big part of this progress comes thanks to the Japan Commercial Arbitration, JCAA. As we have heard from Mr. Kitagawa, JCAA is very notable for its strong track record in international arbitration, with 90% of its cases during the last 5 years to the end of 2023 being international arbitration cases. The top jurisdiction of origin among the non-Japan parties in the cases was China, signifying that Chinese business continues to be a key player in international commerce with Japanese business. And the Japanese government has also been making efforts to promote international arbitration in Japan, as Mr. Kitagawa told us, for example, by bringing Japan's Arbitration Act in line with international rules. As background, Japan's Arbitration Act was modeled on the 1985 Unsettled Model Law, and therefore needs some catch-up to align with the 2006 Model Law. And so, for example, recent amendments included the adoption of the specifics for issuing court orders for the enforcement of interim measures. Another notable amendment came in the form of legislation to implement the Singapore Convention. As is often the case with the Japanese laws, the implementation legislation has quite a long name, so I shortened just the Implementation Act. This Implementation Act was approved by the Japanese Diet in 2023 and came into effect this year on April 1st. These are just a few of ways that the infrastructure for international arbitration is steadily expanding in Japan. The speakers who will be sharing with you the insight into the Japan's practice today are the first-rate arbitrators in Japan. Together with the distinguished speakers from China and other countries, who we are honored to have join us in Tokyo today, an excellent panel has been organized for this summit. I look forward to in-depth discussion with the future strength of communication between China and Japan. This brings me to the end of my remarks. Thank you very much.
Thank you, Professor Abe, and thanks to all our privileged speakers. Thank you for all your wonderful speech. So let's give them a big clap. On behalf of all the organizers, I would like to extend our appreciation to our supporting organizations and media partners. They are Asia Case Management Center of AAA ICDR, Asian International Arbitration Center, Australian Center for International Commercial Arbitration, China Society of Private International Law, International Online Dispute Resolution Center, Hong Kong International Arbitration Center, Japan International Dispute Resolution Center, New Zealand International Arbitration Center, Singapore International Arbitration Center, Singapore International Mediation Center, Arbitration Institute of Stockholm Chamber of Commerce, World Trade Center Macau Arbitration Center, and Association of China Lawyers in Japan, Waters Kluwer, and Lex PR. So let's give them a big round of applause to express our gratitude to their kind support. I also would like to thank all the participants for interest and effort in helping us make this event possible. So this concludes the opening section. I now turn the meeting over to Mr. Tony Andrew Ortiz, the moderator of the next section. So Tony, yeah, the floor is yours.
Do I get the floor or do I get the panel?
Yeah.
Sounds good. Okay, I think I just want to invite up the panelists now. Your names are there. I'm going to start by singing the first song from Frozen. So bear with me. Please sit down. I'm standing because I have a bad back. Testing. Well, I gotta say, I'm thoroughly impressed by the perfect timing here and by the pronunciation of my last name, which I sometimes have difficulty with. So thank you very much. So my name is Tony Andriotis. I'm a partner with DLA Piper here in Tokyo. I'm also the professional institutional officer for the Japan Commercial Arbitration Association. It's an honor to be here. This is the first time I've been dealing with a panel with this type of format. We're going to have the delivery of a report first, and then we're going to have some commentary. Some of the commentary may touch upon the report, but I think most of it will not. It will be just a general discussion about commercial arbitration here in Japan. One of the points I'd like to make to people coming to Japan is it's not a jurisdiction like Hong Kong and Singapore, which I call colonial jurisdictions. They're not, and China's also not a colonial jurisdiction. They don't have that English language, English mentality, British, the sun never sets on the empire mentality, and that's a wonderful thing. That's something we should applaud about both jurisdictions of Japan and China, and I think that's a point of interaction, a point of cooperation that they can find and move forward to. And this is not an insult for Hong Kong, by the way, at the end of the table, just to be clear. So let me just start by introducing the reporter, and then we'll move on to the panel. So the reporter is Mr. Fei Ning, is that correct? He's from the Huizong Law Firm, is that right? Okay, so please, I'll leave it to you to give us a little bit more information about you, Mr. Ning, and then just go straight into the report, please. Sure. Thank you. Oh, okay.
Good morning.
Sorry.
Good morning, ladies and gentlemen, distinguished guests. It is my great pleasure to be here to present the summary of this report. I know it is impossible for me to touch everything or every detail within about 10 or 15 minutes. So I would like to structure my presentation in the following structure. One is overview. The second is updates of major developments. And the third is case studies. And fifth, hot topics of this year. Well, for overview, there are several overviews. Overview 1. Last year, China made a significant progress in legal governance. First of all is our arbitration law amendments. As you may know, our arbitration law amendments, the first draft was published in August 2021. And the second draft actually just published in last Friday evening, which actually for public discussion. I'm sure most of you have read that, but not in detail, same as me. I just quickly went through the second bill. I personally noticed that something is very positive to support arbitration, but some items I seriously believe that it was for us to negotiate or discuss. We will do that later, but not now. It's not included in this report, just a heads up. Secondly, the civil procedure law came into effect in the beginning of 2024. Introduced two new changes significantly, specifically relevant to the arbitration, which I will detail shortly. And also Supreme Court issued a judicial interpretation on the contract chapter of the Civil Code, which shows the pro-arbitration stance. There is no annual report from SBC, Supreme Court, last year regarding the judicial review on arbitration award, but the regional reports from the courts in Beijing, Shanghai, and Zhejiang have indicated that the pro-arbitration stance of Chinese court remain unchanged. For example, for Beijing court, there were about 1,000 cases to applied for dismiss in 2022. So the total setting aside rate is below 7%. For Shanghai court, in the last 5 years, the setting aside rate still remain below 0.5%. Overview 2. In the past year, the government has been actively implementing the composite measure to establish international arbitration center in several key regions. This measure including exploration of ad hoc arbitration in pilot area and inviting foreign arbitration institutions to operating within China, within some particular regions. To assist this effort to improve the arbitration service, several prominent Chinese arbitration institutions have launched their new rules incorporating many new amendments reflecting the best practice of international arbitration. A few courts, local courts, including those in Shanghai, Shandong, Xiamen, they rendered new rules to assist evidence collection and the preservation method in arbitration proceedings. One matter actually also not included in this report is another new case which came out 2 months ago for Beijing number 4 intermediate levels court, which actually the court first time confirmed the decision made by tribunal, which actually BAC tribunal issued interim measure order, which actually normally, traditionally, such measure should, forward to PRC court to ask the judge issue that order. But for that case, tribunal made their decision on the interim measure, and following that, the PRC court confirmed and recognized that decision, and issue kind of order, confirm that tribunal's order, which actually has never happened before. This is also the new situation or new development. And overview 3. Last year, arbitration practice in China also reached an unprecedented milestone with the national case volume exceed 600,000 cases and the disputed amount close to 1,200 billion RMB. Highlight 4. The Civil Procedure Law, also amended last year, introduced 2 changes that will benefit the enforcement of foreign arbitration award. Before the amendment, the nationality of award was decided according to the place where the arbitration institution located. So, for example, if the ICC award issued in Hong Kong, normally previously, according to civil procedure law, we treated that arbitration award issued in France because this is the arbitration institution located. However, for a case which you may know is a Bandwood case, which actually happened in 2020, issued by Guangzhou Court. That case, that decision made by the intermediate levels court in Guangzhou, but supported by Supreme Court, which things is ICC arbitration, the case seat or the award issued in China, not ICC, not in Paris. So in that case, PRC court treated that award as a Chinese award rather than international award or foreign award, but it's a foreign-related disputes. That's the first time. And for such amendment, which actually changed the previous concept that the nationality of the award will depend on the institution, where the institution located. But now it's based on where the award, where the seat of arbitration. For example, a party choose Singapore arbitration or ICC arbitration, but the seat of arbitration might be not in Singapore, not in Paris, maybe in Hong Kong, in Malaysia, maybe in China. So basically, PRC court will based on that new concept, seat of arbitration, to treat it as an international award or Chinese award, domestic award, but it's foreign related. This is a new development. And highlight 4, civil procedure law extends criteria for enforcing foreign award. Previously, there are 2 requirements. One is as long as the respondent be domiciled in China. 2, have assets within the country, within China. The new rules allowed additional connections if the applicant domiciled in China, or the absence about such connection, but enforcement may still be possible if any relevant connection to the disputes involving the award can be found. So clearly, this amendment demonstrates that the more open and supportive stance toward the enforcement of foreign award. And highlight 6. I'm not sure. I only have 10 or 15 minutes. Let me know how much time I have.
You got another 4 minutes.
Okay, I try my best.
And 22 seconds.
Okay. So international centers. China also eager to establish our own or its own leading international arbitration institutions, Beijing, Shanghai, Chongqing, Hainan. They have intensified their efforts to build up a world-class international arbitration center. They put different emphasis into practice. Beijing, for instance, encouraged the application for foreign laws in arbitration held in Beijing. Shanghai, on the other hand, has concentrated on establish an ad hoc arbitration in Shanghai. So last year, KCBC set up their Shanghai branch and has become the first foreign arbitration institution that operates their business in Shanghai. Highlight 7. Both CTEC and SHIAC launched their new rules from beginning of 2024. The new rules, both institutions have incorporated significant amendment to adapt to the latest developments in international arbitration practice. These updates including online arbitration, digitalization, emergency arbitration, early termination, and third-party firm, etc. Notably, from highlight Hong Kong Arbitration Center, they also published their new rules, which some new rules regarding like diversity, ESG, and security for data. So this will be touched by my commentator, Ms. Chen. Highlight 8. The credibility report for Chinese arbitration institution was released last year. So among about 76 arbitration institutions participated that survey. So among about those arbitration institutions, there are like 5 arbitration institution score is above 80 point or 81 point. And some of them about maybe 28 or something, about 70 to 80 something. But actually, which also showing that it's such as it's better, the performance is better than before, but still some unbalance. For example, Eastern area and Western area. The arbitration institutions' performance are quite different, not well balanced. And some case studies was for me, I just touched very quickly. There are 5 cases. The worst for you to read. One is a sports arbitration in China. The other one is the main contract, whether the main contract, the arbitration clause in the main contract. Does it applies to the ancillary contract? And the third is when the order to re-arbitration, a question to the court. Because in China, basically, we only set aside. What about for re-arbitration? Go back to the original tribunal. And fourth, interim order made by emergency arbitrator, whether any impact of a Chinese court, how the Chinese court attitude to the emergency order. And the arbitration agreement signed by the bankruptcy administrator or the receiver, whether such kind of agreement made by the receiver is also can be recognized by PRC court. So those cases was to be further discussed. Some very interesting case. But first of all, I just give one example: sports arbitration in China. Previously, sports arbitration in China, the PRC court treated as an internal organ. That organ is not established according to PRC arbitration law. Then later on, according to the arbitration, later on, CA is China arbitration. CCAS, which actually established according to PRC arbitration law. So the PRC judge believed that only that CCAS can handle that case as a final. It's not really. Before that, it's the internal organ's decision. It's not a final decision. It's subject to appeal to PRC court. So that one is a new development in China. However, even for CCAS, they only can deal with the 3 types of arbitration, 3 types of disputes. One is a registration issue. The other one is competitive activities. The third one is discipline actions. However, regarding the commercial disputes arising among them or between them, still subject to other arbitration institutions to solve that dispute, not by CCAS. That would be still a question later on. Then the hot topics. Hot topics. Some hot topics are interesting. Let me have a look. Enlightenment Provision UK Amendment and the right to be heard. Okay, right to be heard in China. Right to be heard in China, we don't have such concept previously, but recently some new development regarding when you applied for setting aside award, whether right to be heard is also to be kind of a procedural issue rather than merits issue. That would be never be discussed before, but we do have some similar case before. I think Hong Kong judge Miu Chen issued some decision regarding right to be heard. And according to the international arbitration practice, such as in Switzerland or DIS, they also have a similar concept for right to be heard. So right to be heard might be a new issue for setting aside award in China in the future. And let me see the others. I think my time is up, but basically, I think if you go back to the report, some new detailed information will be helpful to understand, to have a further understanding about the Chinese arbitration practice. Thank you very much. I hope my report summary is informative. Thank you very much.
I actually have a question for you, Mr. Ning, just a numbers question, if you don't mind. You had mentioned how many institutions, that there are a lot of institutions in China. Do we have a number?
Something like 280 something.
280,
Yeah,
okay.
something, right.
Well,
exactly, I don't know exact number.
I've heard as many as 300, but 280 sounds good. I think that kind of tells us all something about the institution we're here for today, BAC. There are about 300, but there are only 3 that everyone knows and talks about all the time, right? There's this one, Beijing International Arbitration Commission, the BAC, CTAC, and Shenzhen Court of International Arbitration. That just shows how well of a job they're doing here with BAC and BIAC and getting their name out. But that's a lot of institutions. I have another question while we're doing numbers. Could everybody in the room, you don't have to, if you're not comfortable, who's a Japanese national, raise your hand? All Japanese nationals, just raise your hand. Okay. Everyone who is from a Japanese institution, raise your hand. That could be a Japanese law firm or company. Okay. That's important because that's going to be part of our discussion. It's going to be appealing to Japanese users. So this is how we're adding value and to see about cooperation between Japanese and Chinese institutions and corporates and groups, right? That's what excites me about today's session. You know, we always talk about the bad stuff, but we never talk about the good stuff and about building bridges. So I hope today is about building bridges. So first, let me introduce my esteemed panel. We've met Mr. Ning, and I'd like to turn now to Ms. Yoshimi Ohara, who's a partner with Nagashima Ono. Yoshimi, could you tell us a little bit about yourself? Keep it 30 seconds to a minute, please.
Hello, good morning. Ni hao, ni hao. So I'm a partner of Nagashima Ono Tsunematsu, primarily doing dispute settlement, arbitration, mediation, and litigation in multiple jurisdictions. So I have been sitting as arbitrator, sole arbitrator, presiding arbitrator, got involved in disputes between Chinese party and non-Chinese party as well. Thank you. So I should stop here.
Thank you very much, Yoshimi. Now, Mr. Aoi Inoue, could you tell us a little bit, you're a partner at Anderson Mori. Could you tell us a little bit more about yourself?
Thank you, Tony, and 大家好. And so I am a partner and head of international arbitration practice of a Japanese law firm Anderson Mori and Tomotsune. And I have acted as counsel in many arbitration cases under major institutions' rules, including HJIC, CTAC, SIC, AAA, ICDR, and JCAA rules. I have experience in arbitration seated in many cities such as Beijing, Shanghai, Hong Kong, Tokyo, and Kyoto, Japan. I also sit as an arbitrator and have been appointed to the panel of the JCAA today. So I'd like to comment on this background. Thank you.
Okay, thank you. And last but not least is Ms. Feng Han Chen, who I think we've never actually met before, though we're working together on an arbitration now, I think.
Yes,
So
Jessica.
nice to meet you.
Nice meeting you too.
Okay, so please, you're from the HKIC, and again, please forgive me for my anti-colonial comment earlier.
It's fine.
Thank you for the forgiveness. Thank you.
Good morning, everyone. I'm Fang Han Chen. I'm Deputy Managing Counsel at HKIC and oversees HKIC arbitration team's case administration and also serve as Tribunal Secretary. Before joining HKIC, I worked at another international arbitration institution in Hong Kong. And I would like to thank you for BIC, IPBA, JCA, and JIR for having me today. Thank you.
Thank you. Okay, so let's just dive right into it. So I'll start with you, Yoshimi. Start with, we're dealing with increasing emphasis on improving efficiency in international arbitration across the globe. With recent developments in Japan, which were touched upon in the opening statements, such as the amendments to the Arbitration Act, how do you think these changes will impact the efficiency of arbitration proceedings? Are there specific areas where you believe Japan could lead in promoting faster and more cost-effective dispute resolution, particularly in cross-border disputes? Yoshimi?
Thank you, Tony. First of all, let me thank for the organizer, particularly BAC, to come over to Tokyo to organize this event. It's essential, as you know, Tony has commented and Nin has already commented, it's essential for Japanese user to fully appreciate the rule and practice of arbitration seated in China, so that user can get more. Japanese user can get more involved in arbitration. And now I understand that many of the audience is in fact from China and non-Japanese. So I took this opportunity to introduce some amendments relating to amendments to Arbitration Act and Act that relates to the practice of international arbitration. Because for those Japanese user, I'm sure you have heard about this so many times, but non-Japanese users, it could be interesting. So I'm going to point out, 3 amendments, amendment to the law relating to foreign lawyers practicing in Japan. That may not directly relate to the efficiency of the proceeding, but I think it's quite important for you to understand that you can come to Japan and arbitrate and arbitrate as counsel and arbitrate in a case governed by Japanese parties, and arbitration between Japanese party and governing law is a Japanese law to the extent there is some international element. For example, Chinese companies having subsidiaries in Japan and 2 Japanese companies, at least one of them have, parent in China. They have dispute in Japan and governing law happen to be Japanese law and seat in Japan. So, just looking at the party and agreement and governing law, all the elements suggest Japanese. But to the extent there is some foreign element, for example, the parent, one of the parent of the party is Chinese party, you can come and arbitrate by yourself at the JCAA or back, seated in Japan, BAC, excuse me. So that's quite important element, because before the amendment, you really have to change the seat to allow you to represent Japanese party, even if the parent is the party, is a Chinese party that you advise all the time. So it is, Japan open up the market to foreign counsel to arbitrate in Japan. That's number 1. I think it relates to some extent efficiency, because, you as a general, you give general advice to Chinese party, and Chinese party subsidiary happen to get involved in disputes in Japan. You continue to be able to advise and represent those subsidiary of Chinese party in Japan. So I think to some extent it contributes to the efficiency of the proceeding. Second, I will touch on the amendment to the Arbitration Act. One of the key amendments is, as Mr. Abe has already introduced, the clarity relating to interim measures issued by the arbitral tribunal. So before the amendment, the Arbitration Act already provides the ability of tribunal to issue the interim measures, but the requirements effect were not set out in the Arbitration Act. But now, the amended Arbitration Act clearly set out the types of interim measures that are available in the arbitration seated in Japan, which includes anti-suit injunction. So if the parties agree to arbitrate, but one party brings a case to the Japanese court, for example, you can seek the anti-suit injunction to the tribunal seated in Japan, which is quite efficient because having arbitration and litigation on the same subject matter, it really derail the whole proceeding, disrupt the whole proceedings. And in addition to that, Mr. Nin refers to the recent Beijing court decision, which the court recognized and enforced the interim measures, interim relief issued by the tribunal, which is new, but that is no longer new in Japan because the Arbitration Act clearly sets out the enforceability of interim measures issued by the tribunal. So you can enforce the interim measures at the Japanese court. So for example, Japanese party doesn't comply with the interim measures issued by the tribunal. You can just go to the court and enforce the interim measures. And if, with respect to certain interim relief, the court can even issue sanction. Usually Japanese court doesn't have, sanction. There's no contempt of court in Japan. But as a sort of exception, the court has ability to issue sanction penalty if the party doesn't follow prohibitive interim measures. So this will definitely facilitate the enforcement. Another critical development of arbitration in Japan by the amendment of Arbitration Act is expand the jurisdiction of Tokyo District Court and Osaka District Court to deal with cases relating to arbitration. The idea behind that is to accumulate the expertise relating to arbitration disputes in Tokyo District Court and Osaka District Court, so that user can have comfortable in dealing with the specific Japanese court, Tokyo District Court and Osaka District Court, when it comes to arbitration-related matters. And I personally, gave a lecture at the Tokyo District Court, who specialize in this, proceeding relating to arbitration, and they are really, very familiar with and I was very much impressed by their knowledge and also eagerness to catch up with arbitration, not only the arbitration law, but also arbitration practice to help, facilitate the arbitration proceedings seated in Japan. Last point, one last point relating to arbitration amendment is, again, relating to the court proceedings involving arbitration cases. In the context of setting aside an award or enforcement of award, the judge can, discharge the requirement of translation of the arbitral award. Well, perhaps, Chinese arbitration award, you definitely need Japanese translation of the arbitration award when you need to submit the arbitration award as evidence to the court. But if it is English, the court may and possibly, discharge the requirement of translation of the arbitral award. Again, this facilitates the whole process. You don't really need to prepare whole translation of the arbitral award. This is another effort of the court to help the arbitration in Japan. One last point, not relating to arbitration, but it's related to mediation. I hope to touch on mediation.
Yoshimi, maybe we'll deal with the mediation
Okay,
thing
I will do
in
that.
another
Thank
question,
you.
if that's okay?
Yes.
All right, because right now we're sticking with efficiencies, so I wanted to ask you, Aoi, about that issue. Everything, I think Yoshimi just gave us a great deal of information, right? And just in the bridge building tradition, let me just say that don't think that this is something that has been institutionalized in Japan for dozens and dozens of years. When I first got to Japan in around 2010, I think in 2012 I was working on a JCA arbitration, which ostensibly was between two domestic parties, but we all knew it was international. And I was drafting up some of the submissions, and I was told that I could not put my name on the filing. And, I was like, okay, but I wrote it. I'm like, no, you drafted it for us to review, and then we'll put the Bengoshi's name. We're going to put the Japanese lawyer's name on it. And then that was what it was then. Even though ostensibly it was international, we couldn't touch it. We could touch it, we just couldn't brand it. But now with the changes in the law, Japan is much more open to this type of thing. So I don't want you to think that Japan has always been that way, because changes happen in all jurisdictions. And so it could happen to yours, it could happen to your neighbors as well. So just keep that in mind, that change is something that can happen, and it's not as difficult as we think it might be. But Aoi, as we're on the topic of efficiencies, I wanted to ask you, you had busted out a few very fancy Chinese words before, so that makes me think that you have a background in China. Could you tell us a little bit about efficiencies when related to arbitration, specifically dealing with Chinese parties?
Thank you, Tony. And so there are many points to ensure the efficiency in international arbitration, as Yoshimi-san and Tony mentioned. And this first point, I believe this sounds a little basic, but one of the most important things is to ensure the efficiency of arbitration is to proceed with arbitration in accordance with a reasonable procedural timetable or time frames. And so, as you know, in international arbitration practice, it is common for the tribunal and the parties to discuss and prepare a procedural timetable at the stage of procedural order number 1. And so, in this regard, the recent amendments to the arbitration rules of various institutions, including China and Japan, so they have re-emphasized the importance of the tribunal proceeding with arbitration efficiently and without delay. And such arbitration rules tend to strengthen the mechanisms for the preventing delays in the proceedings in various procedural aspects. So one issue recognized is that sometimes it takes a long time from the closure of the proceedings to the actual issuance of the final award. And so in such case, it is difficult for the parties to take measures to address such delays caused by the tribunals. So in this regard, Fanhan may mention later, but that Article 31.2 of the 2024 HJIC administered arbitration rules provide that, so the date of the rendering the award shall be no later than 3 months from the date when the tribunal declares the entire proceedings closed. So regardless of whether or not the arbitration rules, including such a provision, in my view, it is desirable for each arbitral institution to take some sort of measures or initiatives in order to prevent such unreasonable delays in final award caused by the tribunals. In addition to Chinese-related cases, so sometimes the cost of arbitration can be quite expensive, in particular from the viewpoint of translation and interpretation. And I have been involved in one arbitration case seated in Beijing, and we represented the Japanese parties. And in that case, the language of arbitration was Chinese. It was specified in the contract, but the substantive governing law was laws of Cayman Islands. So in order to make some legal arguments based on such Cayman Island laws, we have to prepare the bilingual documents in 2 languages, both Chinese and English. And furthermore, of course, as there were Japanese witnesses, so we prepared Japanese language witness statements, and we had to manage the mutual consistency of 3 language documents, Chinese, English, and Japanese. And in such a situation, it is quite difficult to control costs in arbitration. So, under the arbitration rules, generally the parties' agreements will be respected. However, such prior agreement on the language of arbitration may not be necessarily the best choice in terms of the saving costs in international arbitration. So in such case, so after the arbitration proceedings started, the tribunal and the parties should seriously discuss and make arrangements that to make the arbitration proceedings more efficient, such as allowing the omission of translations of certain documents. That's my experience. Thank you.
Thank you very much for that, Aoi. If we had more time today, we could really dive into the whole foreign language thing and the role of technology and AI is playing. I think AI as a technology is really, when it comes to the linguistic aspects, is going to save practitioners and parties a lot of money, because the way it's dealing with instantaneous translations and interpretations. So we should have an eye on that about technology and efficiency, but not for this panel. I'd like to turn to you, Feng Han, from the HKIAC. Now, keeping in mind what I said earlier about trying to build bridges. We know that in Japan, there are feelings that maybe there might be some credibility issues with Chinese arbitration. How has the HKIAC addressed those credibility issues in a way of, right, you're in a business of getting users. Mm-hmm. So how do you address those issues to attract users to your institution?
Thank you, Tony. Actually, HKIAC, we do recognize the need to safeguard the integrity of arbitration. Especially, we have introduced several provisions within our 2024 new rules to address this concern. And first, in terms of the constitution of tribunal, HKIAC actually plays a crucial role in maintaining the integrity of the process. For example, we have the appointments committee in which the 12 members of the committee will vote on whether candidate we should appoint, and you can look at the profiles of all the 12 committee members' background on our website. So this is quite transparent. And under the 2024 rules, when confirming arbitrators, HKIAC considers their integrity, and in exceptional circumstances, which is very rare, we can revoke an appointment if an arbitrator is unable to fulfill their functions in accordance with our rules or within the prescribed time limits as introduced by AOE. We now have a very stringent time limit for the tribunal to render the award. And additionally, under the new rules, HKIAC also has the authority to review and, if necessary, to adjust the fees and expenses of the tribunal to ensure transparency and fairness. Because in HKIAC, our default method for calculating the tribunal's fees and expenses is by hourly rate. So there is a possibility that the fee note submitted by the tribunal members would be unreasonably high. That's why we added this new rules so that HKIAC may have the power to review the tribunal's fees if needed. And second, we reinforced the tribunal's power to maintain the integrity of the proceedings. For example, we've seen cases where parties change counsel after the tribunal has been constituted, which can sometimes cause conflict of interest. And sometimes this act of changing counsel after the constitution of the tribunal may be rather strategic. So under our rules, Article 13.9 empowers the tribunal to exclude proposed replacement counsel if there is a risk of conflict, and after consulting with the parties. I think those are the major new rules in HKIC rules to protect the integrity of arbitration.
Thank you, Fang Han. And when you mentioned before about the time limits on issuing the award, what is the tool you use? Is it also reducing the fees to the arbitrators? In other words, if they're a month late, they lose 2%. Do you have a set penalty for it, or is it just a rule?
I would not say it's just a rule, but we do not have like penalty under our rules for the tribunal to keep the time limit specified in the rules. But I suspect there will be a problem in terms of enforcing the award if the tribunal does not follow our rules.
But your rule allowing you to deduct from the fees seems to be a good way to incentivize the arbitrators to issue their award on time, though, right?
Yeah, maybe it's good for the parties.
Take that back to
but
Hong
it's
Kong
not
with you. I'm not going to
attractive
charge you
the
for that idea,
arbitrators.
okay? I'm not charging you for that idea. You take that with you. All right, let's move on now. Now, I'm going to stick with you, Fang Han, because you were very efficient in your answer. So, if we're looking at the institutional side, Hong Kong has well-established ad hoc arbitration services, whereas ad hoc arbitration is still relatively new in mainland China. Could you elaborate on the role of arbitration institution in facilitating ad hoc arbitration? And how do you see the role of institutions evolving as ad hoc arbitration gains more traction in mainland China? And one more question of my own I'll add to that is it even legal in China, ad hoc arbitration?
Thank you, Tony, for your last question. I don't think I'm in a position to answer, but I think maybe the new amendment to the PRC law, PRC arbitration law, will answer this question. I just would like to share HKIC's experience in this respect. As a default appointing authority for ad hoc arbitration seated in Hong Kong under the Hong Kong Arbitration Ordinance, HKIC actually provides critical services to ensure that the ad hoc arbitrations run smoothly. In that role, HKIC will first determine the number of arbitrators upon the party's request, which we call it a Form 1 request. And secondly, HKIC will also appoint an arbitrator upon the party's request. And these two functions are also performed by HKIC's Appointments Committee, which I just introduced before. So it's a very transparent process. And for ad hoc cases under ancestral rules, HKIC can also perform as appointing authority upon the parties' agreement. So HKIC can also appoint an arbitrator for ad hoc cases under ancestral rules, which is also performed by HKIC's appointing committee. Apart from those functions as appointing authority, HKIC can also provide fund holding services, ensuring that the tribunal's fees and other arbitration-related costs are secured in ad hoc cases. And in addition, we provide tribunal secretary services, which I personally sit as tribunal secretaries in those kind of cases. And we also provide hearing facilities, including online hearing platforms, which have become increasingly important in this digital age. I think those are HKIC's experience serving or helping the ad hoc arbitration seated in Hong Kong.
Thank you. And just to clarify, Fei, is ad hoc arbitration legal in China?
For the new amendment, the latest, the second draft for public discussion, which actually contains some items regarding the possibility of ad hoc arbitration in China.
Okay.
Which actually the draft gives some items which actually is limited permission for ad hoc in China. For example, in special zone, like a special pilot zone, and within that special zone, and the company or entities within that zone, among them or between them, they can arrange some kind of ad hoc arbitration. Okay. So it's a kind of exploration at the beginning, as a kind of try or kind of alternative or supplementary to institution arbitration traditionally to Chinese arbitration practice.
Okay.
Yes.
Thank you. That really answered my question. Now, I'm going to go back to you, Yoshimi. I cut you off rudely before when you were discussing ARB, MedArb. You're about to discuss it, but that gets me thinking, as ARB, MedArb, and all these other interesting innovations, how do we make Japan and China more attractive seats? Like thinking about these innovations.
Thank you, Tony. I try to be more efficient this time.
You were brilliantly efficient before.
So, the key attractive elements of seat in civil law jurisdictions, such as, seat in China and seat in Japan, is the arbitrator's proactive approach in arbitration proceedings. In common law jurisdiction, arbitrators tend to sit in a back seat during the up until the hearing, and after the conclusion of the hearing, arbitrators perhaps during the arbitration they are going to ask questions, but until then, arbitrators tend to sit in the back seat, let the parties play the game. Whereas, the arbitrators in civil law jurisdictions tend to be more engaged in arbitration proceeding from the outset, setting out the issues, sorting out the issues, and, try to limit the scope of disputes from the outset, and perhaps limit the document production more and limit the cross-examination more during the hearing. So that is a sort of attractive element, but at the same time, we should be very much careful because the user of arbitration proceedings are not just civil law jurisdictions parties. And even, parties in civil law jurisdictions, they may wish to use more, liberated arbitration proceedings, which are often used in common law jurisdictions. And one of the examples is the use of mediation or settlement facilitation in the course of arbitration proceedings. Settlement has been heavily used perhaps in particularly Asian region, because settlement is soul and heart of dispute settlement proceedings process or method among the Asian parties. The question is how to facilitate settlement in the arbitration proceedings. In the Japanese court proceeding, the judge acts as a mediator towards the end of the court proceeding and somewhat force the parties to settle. But that approach may not be appealing to parties in arbitration proceedings from various jurisdictions. So facilitating settlement, the proactive arbitrators are attractive elements, but we should be mindful of the users, diversity of users.
Okay, thank you. And though we're out of time, I'm going to be a rebel and ask one more question to you, Aoi. I want to end on a bridge building note. I do like building bridges. I wanted to be a bricklayer when I was in kindergarten. So what are the key challenges and opportunities in ensuring effective cooperation between arbitration institutions in both China and Japan? Please.
Thank you, Tony. And so, as discussed, so that both Japan and China are actively working to improve their arbitration legislation. So I believe such effort will enable the two countries to jointly promote international arbitration in East Asia. So this will build a relationship of coexistence and co-prosperity in international arbitration community. So on the other hand, there is issue of languages. So I have to say that there are some disadvantages for both Japan and China compared to jurisdictions where English is official language. And from such a perspective of dialogue between Japan and China to promote international arbitration, we have to say that there is also a language barrier. So for that reason, I believe it is necessary to increase opportunities for discussion between the arbitration committees of both Japan and China about international arbitration regime of both countries. So there is a great significance in holding events like this conference, where arbitral institutions and practitioners from both countries participate and exchange views. Thank you.
Yeah, that's a very good point. I think, as I alluded to in the beginning, you may have a big picture problem, but solutions are found on the professional person-to-person level. This is how we solve problems on the grassroots level, amongst friends, amongst institutions, amongst professions. So let's keep that bridge building spirit along with us for the rest of the conference. And I thank you all. I thank the panel. I thank BAC for inviting us all here. And let's move on to the next panel. Thank you, everybody. Thank you. Sure, I can do that. Well, we fixed it. Nice to find you.
Thank you so much for moderating.
Thank What time is yours? Starts at 6:10 actually. Sounds good. All right. And then we can think about it. Right? Yes.
知识产权本身技术仲裁本身就是一个新的方面，就是知识产权侵权这块应该是法律人之间不会有协议，更多的 arbitration 的协议就是基于它那个授权，或者是一种。
Hey, my friend, finally we have you.
但是如果你要说一些直接的那种协议，其实现在是一个新的领域来讨论可不可以，因为它要看一方面国权力，它会多大，比如说知识侵权协议、民事境内、劳动责任、劣币性，所以呢，其实是下一周。在下一周，在这来参加，下一回这个周有一个说是关于这个知识产权的仲裁，下一周18号，但我不是在那个台，在另外一个台。这个部分呢，知识产权的中心的申国仲专门有一个做知识产权的仲裁这一块，有一个仲裁院来研究知识产权。对，我知道，因为其实你们没有来，其实 就是在上个月的25号，10月25号，在申国正有一个 FCPA 的仲裁日。这个仲裁日的其中一个话题就是知识产权的仲裁，但你们华人没有人来，发了邀请但没人来。
关键是在国内做仲裁、知识产权，我们觉得就是必要性不是那么大。
他看情况，他如果商业安排是可以，但是如果是纯粹侵权的，就应该他不。
think you want to keep it on.
Yes.
Okay.
Attention, please. Please be seated. Yeah.
Maybe we just give the people a few more minutes. Good morning. Now we're in session 2 of the 2024 Tokyo Summit on Commercial Dispute Resolution in China. The topic of session 2 is commercial mediation from the user's perspective, expectations, challenges, and the way forward. My name is Yutaro Kawabata. I'm a partner at a law firm called Nishimura Sahi in Tokyo. It's a pleasure to serve as a moderator for this session, and I hope to continue building the bridge where Tony, my good friend, has started at session 1. He's over there. So today we have one reporter, Terrence Xu, and also 2 commentators, Mr. Takatori and Dr. Miyatake. Let me just introduce Terrence first. Terrence acted as case manager, advisor, senior brand manager, and division chief at BIAC from 2020 to 2023. He has handled over 1,000 arbitration cases under the species of BAC and BIC's arbitration rules, and reviewed nearly 5,000 arbitration cases within his division while he was there in that organization. He is the committee member of Sanya International Commercial Mediation Center and was in charge of BIC's mediation work during his tenure. He was also awarded Outstanding Practitioner of All China Public Legal Service by the Ministry of Justice of China. So that's Terrence. And let me introduce you to Mr. Takatori. Yoshi Takatori is a special advisor of Nagashima Ono and Tsunematsu, international arbitrator. He is FCIAR and mediator and admitted in New York and Japan. Mr. Takatori is executive director of Japan Arbitrators Association, co-convener of Japan chapter of CIR, arbitrator at SIAC, JCAA, HKIC, BAIAC, and KCAB, and a number of other institutions. He is also Japan expert mediator at SIMC. He was the only Japanese lawyer in Financial Times top 10 legal innovators for Asia Pacific region in 2019. He has been continuously ranked as Band 1 dispute resolution lawyer by Chambers and named a leading lawyer by Legal 500. He was also very impressive, the mediator of the very first co-mediation under the joint protocol by SIMC and JIMC. And last but not least, Dr. Miyatake. Dr. Masako Miyatake has been practicing law in Japan since 2002 and has taught negotiation, mediation, arbitration, and ombudsman as professor of Keio University Law School until retiring that position in 2024. And she is now serving as a guest professor at Keio University Law School, as well as Kobe University Graduate Law School of Law. She has been teaching mediation courses in Bangladesh, and also Dr. Miyatake's career theme is to explore the most efficient and effective dispute resolution systems for different types of disputes and cases to foster strong connection between practice and academia. She has a PhD in law from Hitotsubashi University and an LLM from Columbia University Law School. So with that introduction, Terrence, can you start your presentation? Yes, thank you. Thank you.
Thank you for the introduction, and I'm honored to sit at the distinguished panel and have a discussion with distinguished panelists today. So distinguished guests, ladies and gentlemen, good morning. This panel discussion is themed as a chance to look at Chinese mediation practice from the user's perspectives. Although none of our panelists were acting as a businessmen in the scenario of dispute resolution, but I bet the panel discussion today will produce valuable insights since we all experience expensive and zero-sum game in the fights over the litigation and arbitration. We all expected better mechanisms of dispute resolution which preserves relationships and add values to the users. And my speeches is prepared in 5 segments. Hopefully it will let you know what to expect whenever you are considering Chinese mediation as a choice. Also, as the last session mentioned, I hope it can establish some grounds for the future collaboration in the mediation field. Starting from the overview, the first observation I made is that China is now experiencing a litigation explosion. As you can see from the chart, the workload pressures placed on the whole justice system of China is alarming to the accessibility of the justice. On this chart, the blue line is the number of the court caseloads per capita in PRC. The yellow and green lines are the numbers of legal service providers, namely the lawyers and the judges. Some observers argued that the soaring caseloads may be attributed to the gross familiarity of the rule of law at the grassroots level of the society. When the economy grows, more often we can see people's interests are interacted, intertwined, and clashed sometimes. Therefore, rules and the institutes which solve the problems according to those rules are much more needed than before. However, my observation is that the resources that the PRC's court wield is far below the needs of the market, the needs of the users. So when focusing the tendency of the mediation, of the mediation, I made the observation that the users in China may expect mediation to become an independent and professional service rather than just a step in the traditional proceedings. As the last panel has already mentioned, in the East Asian cultures, we are getting used to set mediation as a step in the litigation or in the arbitration. But my observation is that users may expect the mediation to become independent. So I made 2 surveys. In this chart, you can see the corporate counsel, the orange chart, and the lawyers, the blue chart, are respectively surveyed. The major part of in-house of Chinese companies tend to be very open to do the concurrent independent mediation when their company is already in the confrontational proceedings. Also, the lawyers in the surveys shows their willingness to embrace the marketplace of the independent mediation. Interestingly, in the long period of practice in PRC, when we talk about mediation, it actually often refers to steps annexed by formal procedures, annexed by the court, annexed by the arbitration, annexed by the some administration's proceedings. And the so-called people's mediation rarely provide independent or active service in the practice. But the users, from my service, the users tend to favor an independence of a mediation service. Then the users also anticipate a higher level of professionalism of the mediation. Therefore, the overview of the mediation in China may tell 2 things. One is that the further development of mediation industry in China might be on the eve due to the litigation explosion. Another one is that the marketplace of an independent mediation service is assured by the user's demands. So with these two things in mind, I listed many legislative efforts in the second part of my article in this blue books. The page 81 is my article. So I will not go through the details of those legislative documents. But in general, the efforts last year came from different branches and aims at the same goal, highlighting the credibility of mediation and building the mediation industry's capacity. I would say that, in general, the essence of last year's legislative efforts placed much more focus on solving the hurdles of legality and accessibility of mediation services. One example is that the policies updated last year regarding to the state-owned enterprises decision-making process. Some of you may know that the SOEs in China constitute a good number of the dispute resolution users. But their rigid decision-making process, internal process, which focuses on the leadership responsibility rather than the merit of the settlement, often makes themselves reluctant to use mediation. And two policies last year has been issued by the State-Owned Asset Supervision and Administrative Commissions. These policies addressed on the problem. In short, these two new policies requires the SOEs to try mediation first as a requirement and make meaningful participation of the mediation process. As shown in the right-hand structures I listed on this slide, in my opinion, I think the stakeholders of the mediation industry or the efforts is going to promote mediation could be categorized as a contribution to the legality, accessibility, process, and skills. When we look at the legislative efforts last year, more efforts, I will say, contribute to the legality and accessibility aspects than the process and skills aspect. Well, some scholars and some practitioners may argue that mediation is a form of art, so no bother to set rules for the process and skills. However, in my view, lack of unified rules or lack of the basic rules poses challenges shown in these two following surveys. In these two charts is another two surveys I made. So on the upper column shows that nearly all the users gains actual experience of mediation through a court-annexed mediation. It may reflect that users are unfamiliar with the process of independent mediation. On the other hand, the lower column may reflect the adjudicative roles and the mediative roles at the same time by the same person could be counter-effective when exercising the mediation skills. For example, in the lower column, it reveals that the parties' concerns, one of the most parties' concerns of the unsuccessful mediation is unforeseeable timeline and the waste of time. I predict, based on my personal experience, the cause of this concern is because when you put the mediation inside the formal proceedings, litigation, for example, and when you do the mediation, the litigation could be halted unless the judges think, well, there's no need to mediation more. So that could drag on the litigation, prolong the procedures. So that will anger the parties if they hasn't the correct expectation of the mixed mode mediation. However, I think the persistence of mediating the case, the persistence to the parties, could be the good quality of the independent mediation services. if we simply separate the mediation process from the litigation process. Also, to understand China, I think the role of institution is also important when we look at the development of mediation industry. I used 2 cases to demonstrate here, but I listed more cases in my articles. So the first case is straightforward. It's a refund dispute arise between the Chinese buyer and the Kazakhstani seller. While the seller wanted to take advantage of the costly and uncertain cross-border litigation, the buyer sought help from the Belt and Road Initiative Mediation Center, the BRI Mediation Center. In this mediation, the center staff captures the dynamic of the disputes and invite a Kazakhstani nationals to successfully mediate the dispute. I think the cooperative practice between the Chinese mediation organizations and the foreign mediators or foreign professional individuals represents the core concept of the Belt and Road Initiative, the spirit of joint negotiating, building, and joint sharing. Having said that, I would bet that the mediation would be a promising field for the international practitioners who want to take part in Chinese dispute resolution market. The second case demonstrates advantages of the ARP-MED or the MED-ARP practice under the arbitration institutions in China. As some of you may agree, the complexity of the construction disputes makes a party concerned less likely to agree on the same version of the story. So when the dispute arises, in many cases, the party has different version of the story. So it's hard for them to directly get into the mediation and seek the fruitful, mediate settlement. In that case, I think certain fact-finding process seems necessary to establish a ground for the talk. So arguably, the two-hatting mediation issues might be efficient or effective in this scenario. That helps the party save time and energy since the arbitration or the litigation has a very efficient fact-finding process, at least in the civil law countries. So that is what happened in these 2 cases. The BAC and the SCIA, these are 2 leading arbitration institutions in China, but they also provide the mixed mode mediation services. So these institutions provide great flexibility in combining different dispute resolution process. So through the arbitration hearings in both of these cases, through the arbitration hearings, the parties established the better ground for talking and get a satisfactory result from the mixed mode mediation. I will not go through the details, but I mentioned details in my article. In both cases, I think the institution not only select mediators for the parties, but also support the mediation practice with an effective framework of rules and procedures. Well, as I said, the BAC is a leading player in the field. I will say that interacting with the BAC's team today could be a good way to take part in Chinese ADR service market. So for the international practitioners, the procedures of Chinese mediation, especially the commercial mediation, should not be strange. As at these 2 surveys, you can see from the right one, blue one, many Chinese institutions borrows the rules and procedures from the international peers and resources, such as the UNSTRO rules and guidelines, arbitration rules and mediation rules. At the survey on the right one, the orange one, shows the institutions plays a major role in the selection of a mediator. So I bet the institutions will always provide more information of their practice for you to get familiar with. Okay. In the reform prospect, I will briefly introduce a concept I repeatedly mentioned in my article, the comprehensive mediation pattern. In Chinese is 大调解. So I will argue that the development of mediation in China as an industry is at a crossroad. Since the People's Mediation Law has been the only legislature which ensures the legality of only one forum of mediation, the laws keep silence on the legality of many other forums recently appears in the marketplace. Especially those forums, new forums of mediation are created by administrative and judicial policies, but their legality needs to be confirmed by the legislature. In general, the range of the participants is pending to clarification, and the sustainable way of independent mediation is pending to be reformed. Well, in 2021, the Ministry of Justice of PRC issued a plan for the construction of national public legal service systems. They announced the CMP reforms aimed at integrating all forces of mediation. As I mentioned, the emergence of the different forums of mediation in recent years could reflect the effectiveness of the MOJ's plan within the legal sector. However, my observation is that to better promote mediation as an industry in PRC, the associations of business sectors must be included in the future. At these two charts, a new survey reviews both evaluative and facilitative styles of mediation exist in the current practice. The parties are willing to compromise when the mediator is able to fairly evaluate the merit, and the parties are also willing to negotiate better deals with the help of facilitative mediators. But as what I mentioned in the previous slides, the frustration of the unsuccessful mediation is improper use of mediation skills, considering the wrong expectation of the mediation forum itself. I will argue that while the courts and legal sectors provide training resources to mediators, such resources are not equally accessible in the business sector for the mediators. Due to the time limits, I will go brief in the last part of the slides. These two surveys actually, I will argue that the Chinese court and the policymakers need to invest more resources to enrich the existing mediation practice. And finally, as a main point of my paper, I argue that the uniform mediation legislation in China could be a necessary step to address the existing organizational and procedural problems and will help lay a solid ground for the future success of CMP reform. Perhaps I could relay on my panel speakers' experience on this aspect and bring back your insights back to China. After all, as shown in the right-hand Chinese calligraphy, I believe the He Wei Gui, harmony matters utmost, is a shared culture among our communities. Your valuable input may enlighten us how to deal with the ongoing litigation explosion in China, and more importantly, the exchange today may help us better understand each other and be together promoting the mediation to the users. Thank you very much.
Thank you very much, Terrence. Harmony matters the most. Sounds like a good way to build the bridges. Next, we will have comments from our commentators. So, Dr. Miyatake, can you start with your comments, please?
Thank you, Kawata-sensei. And thank you, Mrs. Xu. I learned a lot from your presentation. And people in BAC, IPBA, JCAA, JIALT, thank you very much for having me today. I'm privileged to be here as a commentator. As Mrs. Xu presented the latest mediation movement in China, I'd like to introduce the latest overview in Japan, as well as one of the most successful cases in Japan, Japan's mediation. Lastly, I'll mention the factors contributing the most successful cases, which may serve a common foundation for building a unified platform between two countries, China and Japan. Since China and Japan share a common background, civil law jurisdiction, so we could collaborate more further to boost the mediation cases for international commercial disputes. So first of all, let me quickly go through the Japanese mediation systems, case laws, and settlement rates. Mediation in Japan has been conducted by 3 platforms, just like China, the court, executive or administrative organs, and private institutions. The court-annexed or court-connected mediation, particularly civil cases, has been sluggish, unfortunately. The number of the nationwide case laws in 2023, last year, slightly below 30,000 cases, shrinking to 10% or 1/10 of that in decade 10 years ago. On the other hand, the number of the family mediation cases, family matters, filed annually nationwide has remained very strong over past 10 years, reaching over exceeding 120,000 cases. So this is 4 times as large as that in the civil mediation. What about mediation in private sectors? This has been also stagnant, sadly, although we had the ADR Promoting Act, but as of the latest statistics in 2011, the certified ADR institution under ADR Act exceeding 120 institutions. But they reported only about 1,500 cases. That means each institution has dealt with only 10 cases per year. It's a sad news. But on the other hand, administrative ADR or executive organ ADR, this is our Japan's outstanding feature. And in Japan's ADR systems, it shows a different picture. The number of the cases handled by 2 most successful administrative ADR organizations, namely one is National Consumer Affairs Center of Japan, NCACJ. This is a slide about NCACJ resolution workflows. And Individual Labor-Related Dispute Resolution Systems, ILDRS. In Japanese, 個別労働紛争解決制度. And NCACJ is 国民生活 Center. The case load is astonishing. NCACJ, a couple years ago, the case load is exceeding 1 million cases. But that number is including the consulting and advices and questionnaire system, inquiry systems. In 2023, NCACJ records between 700,000 and 800,000. The number of the case rolls of 個別労働紛争解決制度 ILDRS records 1.2 million cases into 2023, but these numbers also include the consulting, inquiries, and advices systems. Let me focus on NCACJ. This is the main topics. Most outstanding feature is a settlement rate. Please look at the orange mark, above orange mark. It said that settlement rate is 67% or 89%. The difference between 67 and 89 stands for respondent shows up or not. So 89% out of the real mediation cases conducted. And 67% settlement rate stands for out of the total cases filed for mediation at NCACJ. Now, you may be interested in why. Okay, so these figures, 67, 89, is quite impressive because Japanese civil mediation court-connected one is about 30%, between 35 and 30%. So this is outstanding figures, 89 and 67. So now you may get interest, right? Why, how this figures comes out, right? In my opinion, there are multiple factors attributable. One is, you may see that intermediary services is blanket, go between or met. This is the opposite word of joint sessions. So go between literally means, in mediation terminology, caucus. So mediators meet or talk each party separately. That is a go-between. So they are basically conducting the mediation service, intermediate services by go-between mediation systems.
Dr. Miyatake,
yes,
we're kind of running out of time.
Okay, I'm sorry. Okay, I should skip that. Okay, so my 2 cents, given that the NCACJ, the attributable factors to successful settlement rates is, here's my 2 cents. Japan and China may build up the common platform in e-commerce by private sectors through ODR, online dispute resolution system, by using the strengths of NCACJ expertise. There are millions of disputes arising out of Alibaba, Tem, and Shen, Mercari, Rakuten, and Amazon co.jp. Yes. So it means that there are consumers in both countries, and there are disputes in both countries. So this is the area we can collaborate in the future. I'm just focused on, and also the consumers' disputes. I'd like to mention that. Consumers' disputes have affinity with evaluated approach, which is civil law jurisdictions like Japan and China are very much familiar with. I just focus on NCACJ, but Takatori Sensei has the expertise, the protocol to build up a strong platform. Thank you very much.
Thank you very much, Dr. Miyatake. So we'll move on to Takatori Sensei.
Thank you. Yeah, time is running up soon, so maybe my comment should be brief. But I really thank to the this great opportunity with these such distinguished panelists, and also thanking to the BIAC and IPBA and JCAA, for which I'm a very heavy user, and also as the executive director of the GIAT, I really thank to this opportunity. So my comments should be 3 points. First one is the keyword is a kind of collaboration, as the Miyatake Sensei mentioned, like collaboration between various organizations for cross-border sense, including the cross-culture. And second is the I would like to emphasize the mediation process is the process of picking up the common interest between the parties, even for the evaluative type of mediation. That's the second point. And third, the key is our kind of understanding among the not only for the mediators but also for the between the parties, and including the in-houses and representing councils. Without such understanding for how to proceed, how they should proceed, and what kind of protocol they can have, the successful and efficient mediation cannot be realized. So first, collaboration thing, as the thanking to the Miyatake sensei's mentioning, I was the first mediator for the very first case by the joint protocol between the SIMC and JIMC, Japan International Mediation Center, for which I was the co-mediator with the Gregory Vijayendran, who was the Law Society of the Bar Association, the Law Society of the Singapore at the time. Then we did the co-mediation as by the co-mediator, two mediators. That's not possible for the arbitration, but mediation. That's a very helpful and efficient to understand, not only for the language, but also the legal culture. And on that case, it was between the Indian company versus the Japanese company. So we can really, as a one unit of the co-mediators, we can very efficiently function to pick up the common interest, including the business interests. So I should not step into that, but I really would like to emphasize that for the China side, the BIAC and GIIAT and the JICAA, so we can think about, we should build up some possible protocol between the Chinese institutions and the Japanese institutions based upon experience, although we are on the same background for the civil law background. But we can have such quite cross-border, cross-culture type of the collaboration. That's the first thing. And the second, common interest picking up. Whatever disputes, even without the pre-agreement between the parties, even in the case of very tough disputes between the parties, they can have a common interest. At least they would like to save the cost. They would like to save the timing. And also they would like to back to the business as soon as possible. Or they would like to focus onto their business, not the disputes. That's a really common interest between parties. But sometimes, like litigators who are representing the parties, their interest could be like, ongoing litigation could be quite earning a lot of money for your firm or something like that. So for that sense, we should always think about the common interest, including the business side. For that aspect, I think the in-house's role is very significant. The in-houses has the understanding of the legal issue and also their business interest and how to control the litigators too much spending their time or something like that, and then cross jurisdictions kind of things. Then they should think about kind of a comprehensive one platform in which you can discuss the amicable dispute resolution to pick up the common interest, and of course both parties should protect their reputation and the credibility in the market, confidentiality. The disputes going itself could be harmful for your reputation and credibility in the market. The third, for that purpose, the kind of education or training, maybe that's kind of too much a strong word, but we really should have the in-houses and the users side understanding what you can have an option, what you can have the such kind of a protocol or whatever. Without such understanding, even if there is a kind of potentiality or possible chance to sit down for the amicable negotiation as the mediation, but if without having the reasonable trained in-houses or users, that may not be possible. So the key is the such understanding, common understanding, to pick up and aiming at the picking up the common interest is the key. That's my comment. Thank you very much.
Thank you very much, Mr. Takatori. So Terence, do you have last sort of reply back to those comments? Or
very quick thoughts on Takatori Sensei's comments. Actually, BAC, I think in more than 15 years ago, held the first co-mediation in mainland China, and that solved a lot range of the disputes for two international companies. So I think I fully agree that co-mediation is a very good areas for institutions and practitioners in both different countries to collaborate. And for the mediation, you don't have the problem of the, last session they talk about the permits of foreign practitioners in, but in the mediation field, it's free. Your Japanese practitioners, you can play mediation roles in the disputes relating to Chinese disputes. The second is, I do agree that the mediation is an option for the users, and this option needs to be educated to the market. By whom? By the practitioners and by institutions. Well, that's just two quick thoughts. Secretary Sensei's comments.
Thank you very much. So this brings an end to session 2. We thank the organizers, the reporter, the commentators, and I also thank the audience. So thank you very much.
Thank you.
Thank you very much. I think we should. Thank you very much.
いいえ、全然大丈夫です。全然大丈夫です。全然大丈夫です。全然大丈夫です。すいません、なんか時間配分。ありがとうございます。もともと前のが押してたので大丈夫です。全然大丈夫です。I wasn't really planning to.
So next time, like the termination of contract, recommend them to you.
Thank you very much.
Dispense with the PowerPoint. We don't have enough time. We just send it to Professor Chan, and you can just do like Professor quick taking points. We'll start with the third session now. We've lost a little bit of time, but I've made a deal that I'm going to take away 10 minutes from your lunch. So you'll only have 1 hour and a half for lunch, more than enough, in order that we'll do it. I'll keep strict time. We'll dispense with introductions. We'll start with Hong Chan, who'll give us his report. Hong Chan. When time is up, I'm just going to wrap the table, and then one must stop.
You can tell it's a very strict judge. Thank you for the MCO for your kind introductions. Ladies and gentlemen, good morning. Konnichiwa. My name is Hongchuan Liu. I'm the executive partner of NG Law Firm. It's my great pleasure today to make a presentation on the energy transactions in China. I will divide my report in 3 parts. The first, I will give an overview of the energy transition, just like a snapshot where China stands in terms of energy transaction. And the second, we'll briefly talking about the challenge, especially since we are in Japan, the international challenge the Chinese new energy industries is facing. And the last, I will be talking about, give a few case studies to illustrate what the kind of new legal issues arise in connecting with the new energy sectors. First of all, let's give you some charts illustrate my point. As you can see that, well, it's not in this charter, but it's in the in my report, and China has become the #1 automobile export in 2023, just over exceeding Japan. But the last year, China exceeded Germany as the second in 2022. It mainly contributes to the EV electronic vehicles. You can see that there's a big boom in Chinese electronic vehicles, but it also gave rise to a lot of problems, as we will discuss later on. This came because of reasons. You can see that China remains to be a dominant investors in the energy sectors. The first one is China. It exceeds U.S. By quite a large amount in terms of investment in 2023. And then the last one is European 27 European added up together. So China's number is almost equal to that of U.S. plus the European 27 European countries. This is a huge amount of investment in China in the energy sectors, new energy sectors. And these charters are also related to the ESG technologies. I see that China is still in the world in terms of investment in the ESG investment raising. It's one difference in China from the U.S. U.S. is number second. Number two, the U.S. is mainly raising the money through the VC and PE investment. In contrast, China raised the money mainly through the IPO process. So this charter will divide it in 6 parts. We're talking about China's key energy, the trends of China in the key energy sectors, the projections in the future. So in the first part is about the brown one is about oil demand. As you can see that the China's oil demand will be peak around 2030 and then will gradually reduce. The second charter is about natural gas. Again, China will be peak about 2030 and will be remain more or less stable over the years until 2050. The coal demand, which is quite controversial issues, China will be, according to some studies, China was already peak about 2025, the coal productions, and then will be reduced very sharply for the years to come. And for the electricity generations, and China will continue to increase, including the polar energy productions will also continue to pledge during the same period. And the last charter is about carbon emission. Again, China will be probably about peak around 2025 or 2030, and then will reduce dramatically until the 2050. Since our report was prepared in January or February, I just want to give some the latest development to make my presentation a bit more interesting. There are 3 significant developments in the energy sector this year. The first is an opinion from the jointly issued by the Communist Party of China, CPC, and the State Council, which is quite rarely that the 2 very powerful institutes that issue a policy statement jointly. It has unveiled a set of guidelines to ramp up the green transitions in all areas of China economic and social development. It also set up some of the concrete objects. So by 2030, which is about 5-6 years away down the road, China will achieve a remarkable result in the green transactions. And by 2035, China will, it's about 10 years from now, China will establish a green and low carbon circular development economic system, which is quite an ambitious goal. Another important paper is China issue a white paper on energy transition. This is also quite unprecedented. The China State Council Information Office issued this white paper on August 29th, and basically illustrate China's significant development in the energy transition area. China, since 13th, China has been responsible for over 40% of additional additions in the global renewable energy capacity. The latest one, actually, China has just enacted a new law that happened last Friday. So this morning I was busy to update my slides to, to include the new development. So the China has already have electricity law and renewable energy law and other regulations, but China does not have a comprehensive energy law yet until last Friday. This new energy law basically consolidate the policies and regulations that have been issued before. It emphasizes on the energy securities, especially in light of the recent the complexity and uncertainty in the international geopolitical situations. And also it emphasizes China will accelerate the green and low carbon transmissions, and also to promote the development of renewable energies. But I don't have time to go too much details, but just give you some a flavor of what the new energy law. It basically emphasizes China's policy, the strong commitment to transition to a green and renewable energy. Second, we'll just briefly discuss a few cases in the traditional area. This is cases probably, it actually was arbitrated, it's an international arbitration in one of the leading arbitration institute. Their representatives are present here today. So this involving leading Chinese energy companies, and this was back to 2012 when the Chinese SOEs signed a contract with a Canadian company to bought a stake from local Canadian companies was Target A, sorry, Company T for 8.3 billion. It's a quite big project. And later on, the Spanish company R acquired the target company. The initial investment of the Chinese company is 1.5, and the Spanish company acquired the company for 8.3. After the acquisitions, the Chinese company quickly found that actually the capacity, the reserve of the target company has been exaggerated dramatically. So they sued the company T and company R for violated the warranty clause and committed fraud. So the case goes on for quite a long time, and eventually the arbitration panel found there are misrepresentation in the disclosure on the seller side, which lead to an unjust purchase price. The case eventually settled for over 2.6 billion. This case illustrates that the Chinese, previously the Chinese company, especially the SOE companies, are hesitant to reach a settlement, mainly due to concerns of the political responsibility. They will ask you, so why you settled for the much less than you originally claimed for. But in this case, you can see that as the Chinese companies, especially the leading SOEs, get more experience in the international arbitrations, they feel more comfortable to settle the case at reasonable conditions and terms. I will skip this case. Another case is in the new energy sectors in the wind farm, which is quite, I think it's both quite representative, both in domestically and internationally, because many of these new energy projects was based on the subsidies from the government. So they will not make the project will not make economic sense without the subsidies from the government. But the government subsidies has been facing a gradually phase out stage, so which leaves many parties involved in dispute. In this incident case, the two parties had signed a supply contract for the wind farm, but after they signed contract, the government announced that these particular regions has been identified as a restricted zone for wind farm. So the project has to be suspended for quite a long time until they can renew the project. But during the period of suspensions, the conditions have been changed dramatically. So the one party refused to perform the contract on the ground that the change in the national policies is qualified as a force majeure event. So the key issue is whether the change of policy should be treated as a force majeure event. I think that is very familiar, but also in the international scenario. My panelist, Duncan, will also discuss the force majeure event later on, which is quite a big issue in the international project, international energy projects. Interestingly, the arbitration tribunal found that this is not a force majeure event because the parties are all experienced players in this field, and they should expect it, the potential influence of the national policy changes. And then we are talking about some of the international challenges that facing the Chinese new energy sectors. So when we're writing these articles, that the EU is only start the investigation of Chinese subsidies to the new vehicles, but now it has become real. So in July 2024, EU imposed a provisional anti-subsidies tariff on the EVs imported from China. And later on, in October 4th, 2024, the EU formally issued these policies to levy import duties up to 35% of all Chinese vehicles. So that's have a huge impact on the Chinese EV import into the Europe. And similarly, in September 2024, the Office of U.S. Trade Representative and also has confirmed an increase of tariff on Chinese export, especially in the new energy sectors. So the increase of the tariff will from 25% to 100%. So it's 100% for electric vehicles and 50% for the solar panels and 25% for other products. So that's the situations that the Chinese new energy, which are very successful in the past, are facing. So maybe we have some later on discussion on that, how Trump's come into power will have the impact on the Chinese new energy industries. Lastly, I would just give an example. Do I say you have time?
You have 5 minutes.
5 minutes, okay. So I have 3 cases to introduce, but I will just maybe cut it to 2, and you can read my report if you are interested. The first one is about the jurisdiction, the new jurisdiction issues. The dispute is over carbon emission rights transactions. There's 2 parties in different locations, and they sign a contract. And the problem is that which jurisdiction, which court has the jurisdictions. In the trial court, they think that the company C, the buyer's cities, has the jurisdictions because according to the traditional Chinese civil procedure law, wherever the defendant or the place of contract performance is located should have the jurisdiction. But in the appellate court, the court make a decision that actually the exchange office itself, where it is located, they have the jurisdictions. This is different from the traditional understanding. So that makes sure that no matter where the parties are located, so all these kind of carbon emission transactions will be always heard by the court in where the green exchange office is located. The second case is about the public policies. This is over carbon emission rights transactions. In the instant case, because according to Chinese laws and regulations, that the carbon emission rights can be exchanged, but only through the official appointed places like greenhouse exchange offices. But in the instant case, the parties sign contract and conduct the transactions outside of a green exchange office. So later on, the court decided such transactions is against the public policies. But in arbitration, we see a lot of parties raise the issue on the ground of against public policies, but they really succeed. But at least in this case, the parties that successfully raised the issues on the ground of public policy. But this case is still controversial. We don't have time to go to details, but in the later development, we have seen in some of the arbitration they have different understanding whether the transactions outside of the officially appointed office, exchange office, is legitimate or non-legitimate. So we'll wait and see. And we'll skip the case. So in summary, so what's the trend in the transitional time for the energy sector in China? So first of all, as we can see that China has a strong commitment on transition to the clean and renewable energy, while emphasizing on the importance of the energy safeties in the context of increasingly complex geopolitical environment. The traditional energies like oil, coal, and natural gas are still very important in the Chinese energy spectrum, especially due to the energy safety concerns, but will phase out after 2025 or 2030s. China has achieved a tremendous success in recent years, as I mentioned earlier, but we're facing a very high challenge and tariff, also economic sanctions mainly from the Western countries in the years down the road. And lastly, the legal system challenge, as we just illustrated that there's a new type of cases will emerge due to the nature of the new energy, will constitute a challenge to the existing rules and the legal systems. Let me stop here, and I promise I will learn how to sing well next time when we come to Japan. Thank you.
Thank you very much, Hung Chan. We have 1 minute of dispatch. Duncan, why don't you start with your key takeaways? Both Duncan and Maeda Sensei have prepared PowerPoint slides, but what I've suggested is I will simply send the slides to Dr. Chan, and that can be distributed amongst whoever is interested after today's conference.
Good morning. It's an honor to be here in Tokyo for this summit on commercial dispute resolution in China. As Hong Chuan has identified, the energy transition creates challenges, but also presents opportunities. And I'm going to briefly draw on my experience as counsel representing clients in the energy sector to offer some key takeaways on how parties can monitor, manage, and mitigate risk. And in the interests of efficiency, and we've been talking about efficiency, I'm going to be brief and give you some key headlines, but would be very pleased to discuss those key headlines further. The challenges are clear. The energy sector involves significant capital investment that is often recouped over a long period of time. Regulatory intervention can change the basis on which parties have contracted. Parties' interests can diverge. We're aware of some of the tools parties have contractually to deal with these challenges: stabilization clauses, contractual indemnities, contractual limitations. As a practitioner advising clients, including Chinese clients, on disputes in the energy sector, I would offer 4 key takeaways in terms of monitoring, managing, and mitigating risk. The first is that the starting point in a contract should be for a commercial party to identify the risks it faces. You need to game out what you're dealing with. You need to see what risk may eventuate under the contract. The second point is the importance of clear contractual language. Parties often resort to boilerplate provisions like stabilization clauses, but it's important to use clear language. Words matter to us lawyers. I've had a case where we had all the claims of over $300 million dismissed on the basis of one word solely in an exclusion. So words matter. Better to use precise wording that fits the contract at hand rather than a boilerplate provision. The third takeaway is choice of law matters. Under English law, Singapore law, Hong Kong law, common law systems, for example, the duty of good faith is much narrower than in civil law systems, such as Japanese law. That can be an advantage or a disadvantage, depending on your perspective, but important to take an informed choice of law, recognizing the effect that choice of law has in terms of risk management. I've represented a Chinese client who shifted from Korean law to English law at the last minute, and as it happens, that was a very good choice because English law worked well for them in that case, but important to take a very considered decision on the choice of law. The fourth takeaway is that many disputes in long-term contracts in the energy sector involve termination rights or what is required to vary a contract. Circumstances change, the regulatory environment changes, one party wants to get out of the contract. So particularly important to focus on the language of contractual variation and termination provisions and think strategically about the circumstances in which a commercial party may want to vary or terminate the contract and ensure that those issues are accurately and succinctly stated in the contract. So damages are very important in commercial contracts, and parties should think about damages at a very early stage. What is often surprising and concerning for lawyers from civil law jurisdictions such as Japan, where judges adopt quite a conservative approach to the assessment of damages, that in many legal systems the starting point for breach of contract is that a party can recover not just their sunk costs, not just their reliance costs, but their expectation measure of damages. That if one party terminates a contract, the other party can say, well, this was a 30-year agreement. We're entitled to our lost profits over that 30-year period on a discounted cash flow basis. So this makes damages very important, and there are practical steps that parties can take to mitigate and manage the risk of damages claims. The first is to use clearly worded exclusions and limitations. Parties can limit their liability for damages, can exclude liability for consequential loss. Important to focus closely on the governing law. Consequential loss has quite specific meanings under different systems of law, but when you're negotiating a contract, that is the time to manage and mitigate your risk by using carefully selected exclusions and limitations. And many of the cases I do turn on nuances in the wording of exclusions and limitations. What is an indirect loss? What is a lot of loss of profit? What is a consequential loss? The other very important practical lesson when you're facing a claim in the energy sector, as in other sectors, is to deal with damages issues in a considered way at an early stage, so you can adopt a consistent and coherent counterfactual. Many of the disputes I do in the energy sector ultimately revolve around questions of what is the relevant counterfactual. What would have been the position of the innocent party but for the breach? And it's important to think about these things at an early stage, engage the right expert. I represented a client in the energy sector involving a project in Iraq where the government, the state client, was facing a $39 billion US damages claim. And by engaging with experts at an early stage, getting in place the right set of experts, putting in place a coherent counterfactual, we were able to settle for a minuscule fraction of that claim, by demonstrating that the hypothesis that the claimant had put forward was not feasible. So damages experts are critical. Often lawyers don't like engaging with damages. They kind of focus on interesting questions of law or contractual interpretation, but ultimately, in most disputes, it's all about the money, obtaining or responding to a claim for damages, and therefore important, particularly in the energy sector where the stakes are high, to think about damages in a considered way at the outset and instruct the right expert. So those are my key practical takeaways. As Anselmo said, there's a slide presentation. Very happy to continue the discussion on any of those issues.
Thank you very much. Yoko.
Okay. Thank you. I'd like to introduce briefly about the energy transition in Japan and also energy-related disputes involving Japanese parties. And in the most recent white paper issued by Japanese government in 2024, acknowledges external challenges for Japan in relation to energies. That mostly relates to geopolitical issues such as Russian aggression against Ukraine or conflict between Israel and Palestine, or restrictions of passage through Panama Canal, and also Houthi attacks on vessels in the Red Sea, which caused some change of shipping routes and increase in the cost. But this, as you can see, these challenges are not unique to Japan at all, and these kind of challenges affect any other countries in the world. But something that makes Japan more concerned about these things is there are two things, there are two reasons, and one is that Japan mostly relies on import with regard to energy. So unlike China, I understand that China consumes about 54% of entire production of coal worldwide, but also China produces more than 50% of the coal globally. But unlike China, Japan mostly imports coals and those traditional fossil fuels from overseas. And also, the second point is very simply weak Japanese yen. So these two elements cause great concern about uncertainty and also price increase of energy in Japan, which result in more than 20 trillion Japanese yen increase in 2 years. So in order, and on the other hand, Japanese government expects more demand of electricity due to digital transformation and more use of AIs, and also more projects of like data centers or semiconductors factories in Japan. So given such situation, the Japanese government recently implemented various new legislation on energy. So and such new legislation mostly focuses on green transformation. I don't know whether green transformation is correct, the global use term, or whether it is Japanese English. But when the government says green transformation, that mostly means more focus on renewable energies. And under such new legislation, Japanese government its goal is to make the renewable energy as the main source for power, and it is currently 20% of the entire consumption of energy in Japan, but the government goal is to make it almost 40% in 2013, and also to achieve the carbon neutrality by 2015. And also the government highlights on more specific renewable energy efforts, such as like carbon recycled fuels, or to realize more investment in green transformation, investment over 150 trillions over 10 years from now. And in addition to those renewable energies, recently Japanese government has changed its policy on nuclear energy. During the Prime Minister Kishida's administration, the government actually changed its policy from denuclearization into into active use of nuclear energy again. And recently, Prime Minister Kishida has stepped down, and the new Prime Minister, Ishiba, has been actually reappointed yesterday. But it is reported that the government policy on this renewable energy and also nuclear energy will not change under his administration. So that is a brief summary of the new legislation. And I also want to introduce briefly about energy-related disputes involving Japanese parties. So, thank you. So, the construction of energy infrastructure could cause any kinds of construction disputes that have, such as delay and disruption, or payment issues, or defects in technological issues, or issues such as poor management of the construction, etc. And because Japanese companies are involved in various energy projects, not only in Japan but also in overseas, so they have been facing various arbitration and other types of disputes related to energy projects. And one good example is, I cannot pronounce well, but ICSIS LNG project, which is in the west coast of Australia, which I understand. But this project involves various Japanese companies, like INPEX, which is the biggest Japanese petroleum company, and also several engineering companies of Japan, like JGC or Chiyoda Kako. And also there are other gas companies like Tokyo Gas or Osaka Gas. And this project, in this project, INPEX has faced several. INPEX has already brought several ICC arbitration claims, such as delay in how do I say, the floating. I cannot. Sorry, I do not remember the exact names, but anyway, delay in the supply of the equipment, or I think that's not the one. Yeah. Or disputes with subcontractors, or disputes with those engineering companies. So in addition, so those are about the traditional construction disputes. But when it comes to energy project in Japan, dispute with neighbors actually becomes quite often becomes problems, and the typical conflicts with neighbors are noise and scenery. But in particular, when it comes to offshore wind project, relationship with fishing union could often become a huge problem. Probably it could be somewhat unique to Japan, but fishing union are very powerful in Japan. They are literally they are union of local fishers, but quite often they are connected strongly to local politicians, and if they are not satisfied with some certain offshore wind project, including the amount of compensation, they could apply any kinds of pressures against the project. They can somehow have the local politicians interfere with a project, or they can sometimes physically interfere with the project, or they could bring like legal actions, such as application for interim injunction against a project based on the claim that the project could irreparably harm their fishing rights. So these are disputes with neighbors. And another category is investment arbitration. And Japanese investors have already brought at least three investment arbitrations in relation to Spanish renewable energy project in Spain, and in relation to Spanish government change in renewable energy policy. And also the very first investment arbitration claim against Japanese government is also related to renewable energy. And it was also about Japanese government change in the subsidies for renewable energies. And because there are many foreign investors into Japan in relation to renewable energy, this case has been the development of this case has been really closely watched, but the claim has been dismissed in 2023 in favor of Japanese government. So I think I'm run out of time. Thank you.
Thank you very much. We have 5 minutes now for discussion. Shall we start with Hong Chan? Hong Chan mentioned that he would say a few words. I invite him to say very brief words about the implications of Trump 2.0 on China's energy policies.
Thank you. I think it will have a huge impact. I think in the international trade, it's probably okay because everybody know that even before Trump was elected, everybody know he already make his plan open that they will increase the tariff against Chinese commodities from 60% to 100%. So the parties are well prepared. But in terms of investment, it will be more difficult. In the recent years, many Chinese companies began to invest in especially Vietnam, Thailand, and Mexico for the purpose of avoiding circumvent the U.S. high tariff against products manufactured in China. But under the Trump administrations, all these arrangements, including the bilateral treaties between U.S. and Mexico maybe under revisions, and this makes all these overseas investment unsuccessful, and that will lead to many international disputes because unlike trade, the investment take a long time, and they will put among the different players. So we will see. We expect that. I will expect that there is more dispute involving Chinese parties happen in Mexico, Vietnam, and international forum. Thank you.
Thank you very much. One question for Duncan, and perhaps a minute to answer. It all sounds very expensive, what Duncan has said, the steps that one should be taking in order to avoid disputes. To what extent has mediation been successful or not in your work with energy disputes?
Mediation has been successful. I've had disputes that have settled at an advanced stage after mediation. My experience is mediation has been more successful after the dispute has reached a certain stage, after the parties have exchanged preliminary submissions, have engaged experts, they have a good sense of what the quantum is, and are therefore in a position to have a considered discussion at a mediation. For example, in the $39 billion US claim, that settled shortly before the hearing on the basis of the expert evidence having been exchanged. Our experts highlighted key weaknesses in the other side's case, and that meant they were much more willing to settle at a much lower value. So I think mediation is successful, is a key tool, but often works effectively in parallel to the arbitration process.
Thank you very much. And perhaps the last question, we have a minute, 2 minutes by my watch, but a last question to Maeda Sensei, and that is this. Japan is a net outward FDI, or shall we say FDI exporter. There's not so much FDI going into Japan as Japanese going out into the world and investing in the world outside, beyond Japan. The corollary to the question asked to Hong Chuan, what do you see the effect, if any, of Trump 2.0 on Japan's FDI, outward FDI?
I'm very sorry to say that, but I'm not very familiar with the Trump 2.0 issue. So
the problem is no one is quite familiar.
Yeah, it's very difficult to comment on that issue, but
I think the worry is that he's going to impose at least a 20% tariff across the board, all countries, and probably 100% or more on China in particular target countries. So that may affect FDI, Japan's FDI efforts, not necessarily in the United States, but outside. It may benefit, it may not, it may harm, but perhaps that's all up in the air.
Yeah, that's true. I think Japanese companies have already taken some, measures, countermeasures against that kind of, like higher duties, higher import taxes. For example, by producing, it's not about energy, but when it comes to car manufacturers, they already have a lot of factories inside the United States and also in Mexico. I don't know whether his high import taxes would apply to Mexican imports from Mexico as well, but those kind of countermeasures have been taken already. So I might be wrong, but I do not really hear screams from Japanese companies about this, Trump, administration 2.0. But yeah, of course, it could happen. That more and more cost for Japanese companies, and it could have, of course, but an inadvantageous effect on Japanese economy in general.
Thank you very much. I think that concludes our rapid session. There are bentos at the back, and I think it's now lunchtime. Thank you very much for giving me 10 minutes of your lunch.
Yeah, nice to meet you. Very interesting, wide-ranging discussion. Okay.
Oh, thank you.
Yeah, okay.
Is this for me? Yes. Oh, you're good.
We have prepared a working lunch for everyone. It's at the backside of the conference room. And the afternoon session starts at 2 o'clock p.m. Please attend on time.
No, the book is on something else.
Duncan, take a picture.
Bunch up.
对方是谁啊？安倍吗？安倍，没看到这安倍。对，开灯啊，开灯。
ありがとうございます。
Thank you so much.
好呀，好啊，国内来的。
Nice to see you. If you can share with me your presentation and slides. I already received your attention. Thank you.
Sure.
Thank you very much. Sorry to ask you a tough question at the end.
No, sorry, I'm not quite following those kind of issues.
Thank you very much as well.
No, thank you for your moderation.
I'll send your PowerPoints to Dr. Chan. We can do whatever he wants.
Oh, you made a sensei, yeah? Sensei. Sensei. So only lawyers can be called sensei. Lawyers and teachers.
Professor, respected people. You can also be called Leo Sensei.
Yeah, sensei.
But it's similar term.
Yeah, it's 先生.
But you don't use that for lawyers.
It's just we just show lawyer Liu.
Mr.
Or lawyer Liu.
You just use it quite commonly.
That's what you mean.
It's not the elevated sense that it has here.
Interesting.
Thank you.
Thank you very much.
For your work and for your wonderful book. I will read it carefully.
Yes.
Very timely book.
As I say, it doesn't go far enough. Part 2 will go further.
先生お世話になってます。ありがとうございます。お疲れ様です。先生のセッション見逃してしまって。
Thank you very much.
最好在那边充电。
在充电对，我们是有个签约，马上完了以后。
然这是你可以去仔细。
Hi, everyone. Thank you for coming back from lunch. And I'm told to start promptly on time so that we can move on schedule. So for this hour, we will examine a comprehensive analysis of financial dispute resolution developments in China over the past year. Think about what 2023 has brought us in China. There's a revised company law, a specialized financial course emerging across the country, and a dramatic shift in how we protect financial consumers. These are not just changes on paper. They are reshaping the very foundations of how financial disputes are being resolved in China. For this panel, we have three distinguished voices guiding us through these developments. Our main presenters, Yu Xianhu, is a partner at Transbridge Law Firm in Beijing. He will walk us through his report's key findings. Next, we hear from Michael de Broek, He's a partner at Acrus Law Firm in Brussels, and also Yunuski Yoshishima, partner of King & Wood in Tokyo. They'll give a different perspective from EU and Japan. And now the floor is yours.
Okay, thank you, Malene. Let me start. Good afternoon, ladies and gentlemen. My name is Hu Yuxiang, a partner at Charlesbridge Law Firm. It is my great honor today to share with you the annual review on financial dispute resolution in China 2024. My speech will be divided into 4 parts: the overview, the major laws and hot issues, the case study, and the prospects. Okay, let me start with my first part. There are 5 trends that I would like to share with you during the past year. The first is about the industry distribution. As you can see from this chart, that about 67% of the financial cases occurred in the banking sector, while about 70% of the cases are in insurance sector. In funds, futures, trust, and securities industry, they only took a relatively small amount, about 1% each. The second trend that we observed is that the financial courts has been established in multiple locations in China. In the previous year, we saw the financial courts set up in cities like Taiyuan, Shangrao, Baoding, together with other financial courts established in previous years, such as in Beijing, Shanghai, Shenzhen, and Chengdu. There are almost 10 financial courts already in China. These courts are specialized in dealing with financial cases, and the judges in this court, they are very familiar with the financial industry. The third trend that I would like to share with you is the collaboration between the financial regulators and adjudicators. We already saw in many cases the judges and arbitrators, they might ask the financial regulators for their opinion on whether each party has violated a regulatory rule. And they may decide the burden of proof or even the responsibility of each party based on the response by the financial regulators. The third trend is about the responsibility of financial institutions. We have seen more and more cases, the courts and arbitrators hold the financial institutions liable. And in these cases, the judges and arbitrators, they focus on whether such financial institutions have complied with its legal responsibility and contractual duties. And last but not the least, the fifth trend is that the protection of the financial consumer protection has been further strengthened. The financial consumer protection has moved from the banking and insurance sector to cover trust, funds, and security sector. And as to the type of the investors, it also expanded from regular folks to cover high net worth individuals or even professional institutional investors. In a very important case occurred the previous year, which is a class action securities case. Over 7,000 investors get a full compensation of more than RMB 280 million, fully compensated from a listed company, which is a big step towards the financial consumer protection. In the second part, I would like to share with you the major updates of laws and hot issues. In the previous year, the most important law in China is the new company law, which made over 100 amendments to the old law. Among others, there are 5 issues that worth noting in the financial industry. The first is debt rights and equity rights are included in the scope of asset for capital investment. Then the financial institutions will face more disputes concerning the capital investment and debt collection due to this amendment. The second is the equity transferor's capital contribution responsibility. This basically means that if a shareholder did not pay its capital contribution, then even if it has sold its shares to other shareholder, it will still bear the liability for capital investment. Which means a financial institution can not only ask the current shareholder to pay the capital contribution, but also can ask the previous shareholder to pay it too. That's the second change. The third one is about the timing of equity change. What's the timing? The timing is the update in the register of members, rather than the signing of a share transfer agreement, rather than the register in the authorities. The third change is the acceleration mechanism of capital contribution. The financial institutions can then ask the shareholder to accelerate its capital investment if the company itself cannot pay the debt. The fifth change is that the fiduciary duty and diligence obligations of the directors, supervisors, and the senior executives are clearly defined in the new company law. Previously, there's no clear definition. This is helpful for the arbitrators and the judges to decide whether such personnel has violated their duties in a financial transaction. Okay. The second rule that worth noting is the Supreme Court's interpretation on general provisions of the contract of the Civil Code. There are also 5 issues that worth noting. The first is the changes in the rule regarding the effectiveness of contracts that violates mandatory provisions. This change will have a significant impact on determining the validity of a financial contract. Second is the elaboration of contract validity rules for contract that violates public order and good customs. In practice, we are often wondering what is exactly a public order or public good customs in the financial industry. This is often a question in these cases, and such rule is helpful to determine this issue. Third is the refined rules on the agency authority. This basically means if a contract is not signed by the legal representative of a company, but it is signed by a non-legal representative, for example, a vice president or a vice general manager, so whether such contract is binding to the other party. So this is also helpful when the court needs to decide whether such a contract is binding to the company itself. The fourth change is to clarify the rule that the person with authority counts more than the official seal. 认人不认章 in Chinese. We all know that previously in Chinese legal commercial practice, the official seal is of vital importance. However, there are many cases where someone forged the official seal of the company, or someone who is not the authorized person used the official seal to sign a contract with the other party. So this will arise in a lot of dispute, and such rule is helpful to decide this kind of cases. The fifth change is to clarify that the rules on ultra-virus acts are not limited to guarantee transactions. This means that previously, only in guarantee transactions, because the company law requires that the counterparty needs to get a company resolution before it entered into contract with the guarantor, or otherwise the guarantee agreement is invalid. And the judicial interpretation expanded this rule from guarantee transactions to all the transactions where the law requires a company resolution. Okay, these are the two major laws that I want to report to you today. In the third part, I would like to share with you two cases, which are milestone cases that occurred in the previous years. The first one is a minimum return guarantee agreement. As we all know, in almost every capital market around the world, there is a principle that is highly valued, which is every shareholder should be equally treated, and the capital market should be fair to everyone. This is a principle, right? But we saw in some circumstances, some strong investors will use their advantage to force the controlling shareholder to sign a minimum return agreement to guarantee their minimum return. Otherwise, they won't invest. So, does this kind of agreement violates the public order and good customs of the capital market? So that is what this case is about. We can see from the structure that investor A, he purchased the shares issued by the listed company A, and the controlling shareholder T provided investor with such a guarantee agreement. In this case, the court has three opinions. First, the court thinks that such agreement guarantees the investor's profit regardless of the stock change, which essentially violates the principle of investor risk assumption in the security law. Second, it rules that it contravenes the provisions of the administrative measures, which prohibit issuers and related parties from providing financial compensation to investors. And third, it disrupts the normal trading order of the securities market and jeopardizes financial security and stability, harming public interest. Therefore, it ruled that such agreement is invalid. To give you some background of this case, before this case, there are also similar cases occurs in China. In those similar cases, most courts decide that such agreement is valid rather than invalid. Because those courts think even if it violates the administrative measures, such measures is not law itself. So a violation of a regulatory policy will not constitute invalidity of a contract. However, there is a very big change happened in June 2022, where the Supreme Court issued a milestone interpretation. In that interpretation, the Supreme Court clearly pointed out that such agreement violates the public order and the good customs of the capital market. Then our case just came out. Our case is the first case in China that ruled such agreement as invalid. That's the first one. The second case I would like to share with you is a securities case, which is an asset-backed securities fraudulent issuance case. In China, there's already a lot of securities misrepresentation and fraudulent cases. However, the asset-backed securities, or ABS, is a new category of securities, and such cases are rare. In this case, we can see that the investor Y, it bought the ABS issued by original equity holder D. And in the middle side, these are all intermediary institutions providing different kind of services to the investor, such as asset management service, such as legal service, rating service, and financial advisory services. And the investor sued all these intermediary institutions for compensation. In this case, the courts are of three opinions. First, as to who is the issuer, the court thinks that the original equity holder is effectively the issuer, while the asset manager, although it's called the named issuer, it is not effective the issuer. It is something like an underwriter. And second, as to the legal application, the court think the securities law, even if the securities law did not clearly mention the ABS, it should still apply. And the Supreme Court's interpretation on securities misrepresentation should apply too. And third, as to the responsibility of the intermediary institutions, the court thinks that since the investors relies heavily on all these intermediary institutions' advice and service, and they all failed to fulfill their responsibilities, so they should bear liability respectively. This is a milestone case in the previous year, not only because it is the first ABS fraudulent issue case, but also because the subject amount is huge in this case. The plaintiff asked for a compensation of over RMB 526 million, and the court ruled that the security company, which is an asset management company, is 100% jointly liable. The law firm 10%, the rating firm 5%, which is a lot of money and make a great shockwave to the entire financial industry. Okay. In the last part, I would like to share with you some prospects that we observed. First, in terms of the policy orientation, we will see more and more circumstances where the financial regulators and the adjudicators will cooperate with each other. And in financial cases, the judges and the arbitrators will be more focused on the legality and the compliance of the financial transaction. Second, in terms of the adjudication rules, more and more financial courts will be established to unify the judicial standards. And also, we will see more laws and regulations enacted in the financial industry. For example, the financial stability law is coming out recently. And third, in terms of case types, there will be an increasing number of cases where financial institutions are sued. The reason is very simple, because in recent years, many financial institutions, they lost their case. And the investors is getting very confident. They think they will win. And they think the financial institutions have deep pocket, right? They have a lot of money. And the fourth trend is that in terms of dispute resolution, arbitration will play a more important role in this regard due to the nature of arbitration has confidentiality and efficiency, which is very helpful to solve financial issues. Okay, to sum up, we can see from the past year, the financial dispute resolution is continuing to grow in China. And we look forward to finding new ways to tackle upcoming challenges. Thank you.
Well, thank you for walking us through the new changes that will impact financial arbitration in China. Now, Michael will give us a broad overview of the financial regulation on the EU. The floor is yours.
Thank you very much. So indeed, thank you first and all for having me here. I'll start my timer now because I know that you're very strict on time.
Yes.
Thank you very much for having me here. Thank you for that excellent report. It is not always so easy to comment on an exhaustive report, but I'll do my best, and I would like to focus on a few issues. So I pick in the role of arbitration from an EU perspective, because I'll let you in on a little secret. I'm not a Japanese or Chinese lawyer. So I provide my comment a little bit from the perspective of the European Union and EU operators, EU financial institutions engaging and how they use arbitration to resolve financial services disputes. And so I pick in with the prospects and the industry distribution that you have reported, where only 1% of the disputes relate, if I understood that properly, relates to securities and trusts. And it is my belief, you can tell me in 5 years if I'm right or wrong, that this percentage will grow a little bit, at least from the perspective of European operators. And so to get into that, I'll first briefly sort of give you the overview of the EU regulatory framework. If we could go to the next slide, please. Oh, there we are. There we go. Oh. There we go. So I think it's a truism to say that that capital markets and financial services regulations is complex everywhere, not only in the EU. But perhaps in the EU it gets an additional layer in the sense that it's also a multi-level framework where the primary responsibility for regulating capital markets and financial services relies with the member states. So that is determined in accordance with national law, ordinary national law. Italy, France, Germany, they all are responsible for their own regulation of their financial institutions. But on top of that, the EU has a shared competence to also harmonize certain issues that have cross-border applications. And so what we see is that after 2008, courtesy of the global financial crisis that started with the subprime housing crisis in the US, there is a considerable new impulse in regulation in the EU that has led to, and this is really just a few of them, there are many, many more, of EU directives and regulations that need to be enacted and adopted by the member states. But that means that they have to transpose that into national law, and so there still remain some certain small differences between member states. Now, why do I say that? Well, this means that the Capital Markets Union in the EU is still somewhat fragmented. It is underutilized, and this was aptly noted in the report that was issued this year by Mr. Draghi, the Draghi report, on the competitiveness of the EU market, which as one of the primary recommendations holds that EU operators, EU businesses have to rely more on capital markets for financing. And one of the ways to do that is to diminish the very strict prudential requirements on securitization, on capital requirements. And so the expectation is that in the coming years there will be more activity from EU operators in financial transactions, financial capital structures. Now, also when we were talking about director liability, the framework that I presented means that director liability is determined in fact by national law, and that is usually the ordinary national law on company director liability, but in financial services I always say director liability plus, because it is enhanced by some of the additional rules that are enacted in all of these regulations relating to transparency, reporting, due diligence, fit and proper standards. And so these are all extra requirements that are put on the directors and that mean that they have a stricter form of liability and they are held to a higher standard. What exactly that standard is, of course, there is still some leeway and there are some minor differences between the member states, but generally a normal, prudent director with knowledge of financial markets is the benchmark. That means that also in terms of the structuring of contracts, that means the choice of law is obviously very important, and the law of the establishment of your special purpose vehicle or the issuer will be determinative. Now, what does that provide us in terms of dispute resolution options? And this is where I will start making the link. Of course, the dispute resolution options are to some extent determined by the legal traditions and those are obviously different in each region. What is very important in the EU is, of course, is that when we talk about the users of financial services, we have to distinguish between users that are consumers and users that are businesses, that are sophisticated users. And in that sense, I think that one of the convergences also is that a high level of consumer protection is something that is envisaged now also by Chinese authorities, and that I think generally experience shows that consumer trust means that the market will work better. Consumer arbitration in the EU is not allowed, at least not for mandatory pre-dispute clauses. So ordinary competence is towards national courts. On top of that, there is also the EU FinNet, which is a system of voluntary alternative dispute resolution schemes. They're not hugely successful, I'll be honest about that, because they're mostly industry-driven. So they're a system of ombudsmen. The outcomes are mostly not binding, and you do have to first exhaust the internal complaint systems of the financial operators. So all in all, you know, a good idea, but probably not the most performing system. And then we have something that is entirely novel since last year, the EU Class Action Directive for the recovery of collective harm. And this is entirely novel because it does not exist in most continental civil law systems. And so the fact that the EU has now required member states to enact a collective redress system, and that on top is also not a traditional class action, means that states are not and should not be afraid to tailor their dispute resolution to particular types of dispute and in novel ways, and to experiment with that. And this is clearly an example of that. Secondly, with regard to business-to-business contracts, the sophisticated users of financial services, there we notice that financial institutions are more and more interested in using arbitration. And so,
you have 30 seconds.
Yes, I will make that. So banks and financial institutions tend to prefer arbitration where the dispute or the transaction involved is complex, is of high value, where there is an involvement with emerging markets or enforcement and recognition required abroad, or there is really a need for confidentiality, right? And so, because financial institutions, at least in Europe, generally tend to prefer dispute resolution on financial contracts in courts, but in the situations where these criteria make sense, there's more and more engagement with arbitration institutions. And so I've listed 4 financial services and contracts where arbitration really makes sense, right? Derivative trading over the counter, very complex contracts, usually bilateral, so that means perfect for arbitration, no multi-party problems with joinder. The ISDA Master Agreement now also, but now since 2013, also has a an arbitration clause as recommended. So that means that more and more we see these disputes going to arbitration. And where do they end up in arbitration? Well, depending on the counterparties, of course, quite some of them go to arbitration institutions in Asia, right? Hong Kong, Singapore, Beijing, SIATAC, BIAC, of course, Japan, I'm very certain. Many arbitration institutions, and I'll wrap up with that, have enacted special rules or sub-centers for financial dispute resolution. And so I think these are the areas where, from an EU operator perspective, we will see more arbitration happening in Asia. Thank you.
Thank you. Now we will hear from Ryusuke about financial ADR in Japan, and he will walk us through a actual case going on in Supreme Court right now.
Hi everyone. 大家好。欢迎。My name is Ryunosuke Ushijima. 我是 Newdao. I'm going to provide two takeaways due to the constraint of time. First is the financial ADR in Japan, which is one of the successful ADR system in Japan. And another is Palumco case now pending before the Supreme Court of Japan. First, financial ADR in Japan. This is an overall image of financial ADR system. The administrative authority designate supervisor dispute resolution organization, and member of the committee serve as, including lawyer, serve as the mediator and resolve the dispute between the user and the financial institute. This key feature of financial ADR in Japan is mandatory participation of financial institutions. So financial institution is obliged to participate in the proceeding, and neutral third party mediation, including the lawyer, participates. And first are less costly than the court proceeding. In Japan, different from China, no special court financial dispute. The only Tokyo District Court and Osaka District Court specialized division, but such specialized commercial specialized division does not exclusively handle the financial transaction dispute. And also this is a kind of the mediation, so non-binding nature of recommendation of the settlement. So administrative authority is Financial Service Agency of Japan, and in short, FSA. FSA designated dispute resolution each sector of each financial sector, and in short, DDRO. And actually, so far, only 8 DDR designated. However, if certain sector, such as newly developed sectors, such as cryptocurrency exchange service provider association, they don't have any particular DDRO, but they will oblige to take a certain measure, including the procedure agreement with the bar association. And the bar association handle the de facto DDR. And ADR process is, step one is complaint file, and complaint file DDR, and mediation process started, and the mediator facilitate the party to resolve the amicable agreement, and if necessary, offer the recommendation of settlement. The benefit of financial ADR is for consumer, of course, accessibility and speed, expertise, and financial institutions, reputation management, cost saving. Also, public interest is increase the trust of stability. So the depend on the DDRO, but the caseload is very accumulated number. So that's why I said this is one of the successful ADR system in Japan. And next takeaway is the Palumco case pending Supreme Court. Objective of this introduction is explore the impact of absence of board resolution on the validity of the arbitration agreement. This case actually the enforcement of holding arbitration award, and party is the petitioner. Petitioner before the Supreme Court is a Japanese company, and the respondent is a U.S. company, and dispute agreement is arranged the membership interest purchase agreement between the two company, and this agreement include arbitration clauses. Then this arbitration is purported by the representative of both parties, but the key issue is whether the representative Japanese company had the authority to conclude the arbitration agreement. There is a dispute of the authenticity of the signature of the contract and whether necessary corporate approval, such as the board resolution, was obtained. The arbitration agreement validity challenge based on the lack of the formal authorization, which required under the Companies Act, the contract resulting in the significant amount of the monetary obligation required to be approved by the board resolution. So in arbitration proceeding, however, the arbitrator award issue in New York confirming the validity of the contract and under the New York law, and the joint liability of the involved despite the challenge of authority and authenticity agreement. This agreement itself specifies the governing law is New York law. So key individual is a Japanese company side, Mr. X is a director and alleged representative with authority to conclude the contract. But Mr. Y is the representative director. So under Japanese law, similar to the Chinese law, only representative director have the authority to represent the company. So the issue is presume the authority of director under New York law versus requirement under Japanese corporate governance. So corporate governance, the importance of board resolution, and without board resolution, arbitration agreement may be deemed unauthorized, invalid. Supreme Court precedent, the counterparty knew or should have knew that there was no board resolution rendering significant contract, include arbitration agreement invalid. Failure to consider the board resolution, the original contract, the Supreme Court need to review the validity. Okay.
Sorry to cut you off, but we need to be on schedule. So if I may come back to you, Lucian, for the final remark. Having heard from Michael and Yunuski, what do you see as area of collaboration between China, Japan, and EU in terms of the financial dispute landscape?
Okay, thank you, Malene. I think the collaboration and communication between Japan, EU, and China in the field of financial dispute resolution is very necessary. on the one hand, we all know that China has already learned a lot from developed countries such as Japan and EU in terms of the financial industry and the financial judicial issues. On the other hand, China also has its own characteristics, because things will be quite different if you got over 1 million people, and different places are such different in China. So I think for EU and Japan, it will also get more insights from getting more familiar with Chinese practice, because Chinese practice also represents a symbol or a case for the developing countries. So this collaboration is very necessary. And for the specific measures, I think the conference that we are having today is the best example that this conference held by Beijing International Arbitration Center is the best example for this communication between different countries and states, and we can cooperate and we can communicate and get insights for all of us. Thank you.
Thank you. That concludes our panel, and thank you for BAC for allowing us to present. Thank you.
Hello everyone, I'm Chun Yuan Zhang from Singapore International Arbitration Center. So first of all, let me thank the BIAC for the generous invitation for me to be here to meet all of you, and also to join this distinguished panel featuring the truly top experts from the IP sector. Today our session is about the IP disputes. You can see that Ms. Zhang Hairuo is already there. Is prepared to do the presentation on the BIAC's annual report on the IP dispute resolution. So maybe we should allow Hairuo to do the presentation first, then we can just get into the discussion part, right? Okay, Hairuo, please.
Thank you, Chun Yuan, for your introduction. Well, my name is Hairuo. You can call me Hai. I'm a Chinese IP attorney. I know IP arbitrations is actually quite a limited amount or limited portion in arbitration world, but also we see there is a growing amount of IP arbitrations in China. Well, regarding IP protection in China, it has attracted a lot of attention from international communities, and there are many aspects to discuss. And due to time limits, don't feel surprised if I cannot cover all the topics in my presentation. So this is the content of my presentation. First, we will start with the overview of the last year's authorization data. As you can see from the left, it is regarding invention patents. You can see for the past 4 years, the granted invention patents has been keep increasing. And also for the PCT filings, China still remain one of the top country of origin for PCT filings. And among those PCT filings, there are a lot of patents relating to AI, big data, and machine learning. And this shows that the Chinese companies increased investments in technology innovation and development. And on the right, it is opposite to the invention patents. You can see for the granted trademark registrations, the data actually decreased last year. And also for the global amount of trademark filings, using the Madrid trademark filing system, the global amount is also dropped. This indicates the challenges posed to the global economy last year. Well, one of the positive aspects is that there is an increase by over 7% of the Chinese companies using the Madrid trademark filing system. This shows that the Chinese companies, they are more actively expand their business to overseas markets and to play in the overseas market. So the next is regarding the trends of the IP litigations. There are many trends last year, and according to our observation, the first one is that the court is now providing more stronger protection to IP right holders. And for instance, last year, there were over 300 cases where the court has adopted punitive damages in IP infringement case. And the compensation is also getting higher and higher. For instance, last year, there is a Supreme Court case, we call it a Millennium case. It is a trade secret and patent infringement case. And the damage award is nearly $30 million. And that case was the highest damage compensation on the record, but until 2 months ago, the Supreme Court has another new case, has broke that record, and the damage amount awarded by the Supreme Court is nearly $90 million. It is also a trade secret infringement case between two Chinese EV companies. So we will see how long that this case will stay as the highest on the record. And the second trend is that although the court is providing a greater protection to IP right holders, on the other hand, the court is also keeping an eye on abusing of IP rights by filing malicious IP lawsuits. And the last year, there are more and more cases where the court found that the party who abused their IP rights by filing malicious IP litigations should be liable for compensate the innocent parties' damages and attorney fees. And the third trend is that there are more and more new types of IP cases brought to the court involving new technologies like AI and machine learning, big data, etc. And we will cover that later on. And also in the arbitration world, although the IP litigation remains the major mechanism to resolve IP disputes, we also see that more and more companies, they choose arbitration nowadays. For instance, last year, there were over 5,000 IP arbitrations accepted by arbitration institutes nationwide. And for BAC alone, it has accepted over 200 IP arbitrations. And the average resolution time is slightly above 200 days. That's a very impressive speed compared with the court proceedings, which could last years. For instance, there are some cases I litigated, it could last over 10 years. And also the court is also very actively promote ADR. For instance, the China Supreme Court has signed memorandum with WIPO. For some local Chinese courts, they could automatically refer some suitable cases for the WIPO Arbitration and Mediation Center to mediate. Next, we will look at some major updates of China IP law. China last year has continued to revise its IP laws. For instance, for patent law, it has revised its implementation rules. And also following that, we also revised the patent examination guidelines. And regarding among those guidelines, there are specific provisions dealing with like AI, big data, etc. And also trademark law is under the Fifth Amendment. And regarding the copyright law, its implementation rule is under revision 2. Well, regarding the part where IP law oversect with the antitrust law, there are provisions to prohibit abuse of IP rights, to exclude or restrict competitions. In jurisdiction matters, last year we have amended the civil procedure law, and there are two major changes. First is under the principle called appropriate connection. Now the China court may have jurisdiction over SCP global rate cases involving Chinese companies. And also, according to the revised law, the China court has exclusive jurisdiction over IP validity cases. Next, we will look at two cases which I think are a good example of the challenges posed by the new technology. The first case is between two direct competitors who provide short video app. And the plaintiff finds that the defendant had grabbed or stolen large amount of its data set, such as the short videos, user information, user comments, etc., and used those data set on its own competing short video app. So the plaintiff sued the defendant before the court. So the core issue before the court is first whether the right over the data set can be protected under China law, and second, under which law? And second issue is whether the accused data set grabbing and usage acts are illegitimate. Regarding the first issue, the court finds that first, under the copyright law, since the data set is presented in non-original manner, so it cannot be protected as compilation works under copyright law. But under anti-unfair competition law, the court found that the data set controller has invested a lot in the collection, storage, processing, and transmission of the data set. So this enables the plaintiff the competitive advantage in the market. And the defendant's act of directly copying and stealing its data set has violated the anti-unfair competition law. So currently, under existing China legal system, there is no specific legal mechanism to provide the protection over data set. And there are three major avenues nowadays to protect data set. The first is under copyright law if it is presented in the original matter. And the second as a trade secret if it is not publicly accessible. And the third is the anti-unfair competition law. And in this case, we just discussed is an example of the third avenue. And nowadays, there are news that the Chinese legislatures, they are considering to revise the anti-unfair competition law to provide a specific legal mechanism to protect data set. The second issue is regarding the challenges posed by AI. Well, AI has brought a lot of challenges to many bodies of law. IP law is actually among the frontiers to be challenged. And in our IP world, there are major topics, like in this chart, can be classified into two proceedings. First is in the input proceedings. The major topic is that, is it copyright infringing if one use others' existed copyrightable works, such as text or images, to train your AI module? And for the output proceedings, the usual topics are regarding the AIGC, AI-generated contents, such as the first issue is it copyright infringement if the AIGC is identical or substantially similar to others' copyrightable works. And for this topic, for this issue, this year we have a court decision involving the famous Japanese cartoon character, sorry, I forgot the Japanese name, Ultraman, yeah. And the second issue is regarding the copyrightability of the AIGC, and this is the case that we will look at. The fact of this case is quite straightforward. The plaintiff used the open source AI module called Stable Diffusion to generate an image, and he published it on the internet. The defendant has saw that image and used that without the plaintiff's authorization. So the issue before the court is whether the AIGC is copyrightable under copyright law, and who should be considered as the author of the image. So during the hearing, the court looked into details of how the image was created, and the plaintiff proves that he has used very detailed instructions or prompts to generate several options of images. And then he selects one appropriate one, and he continued to revise it by adding new prompts and adding new parameters, and he got the final version. And also during the court hearing, he demonstrated the whole process again. He used the same module, same prompts, and he got the same result. So the court's decision is that the plaintiff has proved that he has a great amount of intellectual effort in creating the image. And the creation process can reflect his personal choice, his aesthetic choice, and personality judgment, etc. So the court is convinced that he has sufficient control over the result of the generated image. So the courts give the generator, or say the user of the AI module, the copyright. So after this case, it has sparked a lot of debates and controversial arguments. According to my understanding, this is the first case involving AIGC. Of course, some critics may say that it is too early to reach such a kind of a conclusion because the image like true human authorship, because the user just input the prompts, the text, and it is the algorithm that are run by the AI module, and the author may not have the absolute control over the image. Well, this is a complicated and developing area, and we will keep observing this. And at the end of our report, we have also give our part devoting to the hot topics of the year, like the malicious IP litigation and the liability. We have looked at several court decisions and tried to distill the criteria used by the courts to draw a line between the bad faith IP litigation and the ordinary IP litigation filed in good faith, but the plaintiff was lost. So looking at the future, I think there are challenges and opportunities coexist. And as the rate of the technology innovation accelerates, it is important to have international communication and international cooperation, and also legal innovation. And with these developments, I think we are moving toward the correct direction to foster a more fair and innovative IP landscape. Thank you.
Thank you, Harold. Wonderful, wonderful speech. And I'm also very interested about the case you just sharing about the AI-generated contents. So the leading court decision delivered by the Chinese court. I also have questions about this. I think that my first question is that how the use of AI technology will change the landscape of the dispute resolution in the IP sector. So first of all, I'd like to allow David to share your views on this point. Thank you.
Oh, thank you, Chen Yuan. And you didn't ask me this question before, yeah? And I'm also not an expert of AI, but I want to try to elaborate this question. And yes, and you know, AI will change a lot of things. And Huawei is a high technology company, and we will, of course, focus on this new technology. And I think from Hairuo's slides, we could see that in China there are a lot of disputes increase very quickly, and that is because in China our protection for the IP is strong and strong, and on the other side there are many new subject matter, and in the digital area include AI generated works, I think. And I think we right now we are thinking about not only the copyright protect and competition law protection. We also consider if the patent law is a suitable tool to protect AI-generated works, and we communicate with patent office in different countries, and we discuss about if AI-generated works could be protected by a patent, and if that could be protected by the patent, who is the inventor, and how to decide what the substantive invention, and from a human or from the AI side. I think that will be interest. So we could see there will be more and more dispute because of this new development. Okay, I just cut off here.
I have a follow-up question. Is Huawei using any AI tools to try to write your patents or develop any of your products?
I think we do something like that, yes. And AI tool is a very efficient, yeah, and that could be help our R&D people to develop their technology and develop their products. And sometimes, but I think right now the R&D people and decide what parameters and how to use the AI to invent something new, and how to, if they should go to the patent office to apply for patent protection, and if they should use copyright or competition law to protect that. Of course, that is our legal side to decide. Okay.
Last month, I visited Huawei's headquarters in Shenzhen Bantian. So luckily I met you there. I see the very impressive exhibition hall of Huawei and exhibiting many, interesting products. But I did not see any product relating to the AI tools for the legal service industry. So is Huawei has any plan to develop some very useful tool for the arbitrators or the arbitration lawyers so we can use to make our work more efficient? Do you think it's an interesting market?
I hope it's a huge market. Yeah.
Maybe not huge, but interesting.
Yes, and I think first we are the clients of the lawyers, and we don't want to earn much money from our counsel. Yeah.
Okay, thank you. So now I would like to invite Ayumu to comment on the same question. Specifically, I would like to know, so is there any Japanese court decisions on the AI, the copyright disputes about the AI-generated contents? Can you introduce the latest development in Japan? Thank you.
Okay, good afternoon. My name is Ayumu Iijima. Ni hao, woshi fan tao pu. This is only Chinese I can speak. About AI in Japan, we have no remarkable case judgment so far on AI-generated copyrightable works. But on the other hand, we had a very interesting judgment this year on inventorship in patent law. And in that case, the plaintiff argued that AI can be an inventor in terms of patent application, and the AI should be allowed to be indicated as an inventor in the patent documents. And of course, the court dismissed the case, saying that inventor must be a human being. But the court judgment also said that how to treat AI invention is a very important issue in Japan's industrial policy, and the underlying problems should be discussed in the democratic process. It's basically a legislation matter, and to set up a good legal system to cope with the emerging issues. That is a very interesting, court judgment.
Thank you. I think my second question is about the choice of the dispute resolution methods. According to our recent meetings with users in the tech sectors, I understand that most users in this sector are very interested in the using of the mediation, right, to resolve the disputes. So, David, my question is that, so what is your views about the selection, of the methods of dispute resolution?
Yeah. Thank you, Chunyuan. This is my question. Yeah. Yes, and we have a local department in Tokyo, and Huawei has a IPR branch in Asia Pacific area. Our base is in Tokyo. We have 10 people in our Tokyo office, and why we transfer many Chinese patents or hire some local Japanese people and in Tokyo, that is, we think the communication is very important. And when we discuss about the commercial disputes, I think the base is that there's a lack of the communication. And when we came to Japan, and we noticed that in Japan, and there is no many litigation, patent litigation like China, yeah. And in China, every year we have perhaps 500,000 patent litigation. It's a huge number. But in Japan, every year there are only 600 patent litigation. And it's amazing, yeah. And we consider what's the reason behind that, I think. Because the Japanese companies, and first, they lack peace, and the second, they communicate very frequently. And in this area, IP area, and I think the IP people in different companies, they know each other, and they understand each other, and they learn something and teach by the JIPA, and so they have some consensus, and that is why there's not many disputes. But in China, and we lack this kind of consensus, and this is the problem. And we, before that, we also have some disputes with other countries, companies. But when we came to Japan, and until now, right now, and we have no disputes with Japanese companies, zero. And we reached some agreement, bilateral agreement or cross-license agreement. It's very efficient because we talk each other and communicate each other. I think this is the basis. If we enhance the communication, that will be less commercial disputes. And this is I want to address the first point. And for the second point, I think if there is some dispute between the companies, and we need to find some very efficient way to do that, to resolve that problem. And before I came to Japan, and I'm the chief litigation lawyer in Huawei, and I'm responsible for the litigation and more than 10 years, and I'm very like to litigate before the court. Yeah, but when I came here, I think it's not very good. Yeah, I like to talk. I like to negotiate with other people. And when we have some dispute, and I think first, litigation perhaps is not a very good tool to do that, because it's complicated, it's a long time, it costs a lot of money and time. So I understand many of you is focus is experts of arbitration, and I'm a little confused about the arbitration, because arbitration is a little risk for me, because I don't know who is the good arbitrator in this area, who is good at for the IP area. Just like Hairo said, there are limited amount of number of cases in these IP areas, and even there are some successful cases, and I don't know who did that, and who is the arbitrator, and who is the the good lawyer. And this is one part is my fault because I didn't communicate with many lawyers. And the other side, I think, perhaps is I encourage the lawyers to do something, and perhaps you could more open to communicate with our in-house counsel. Yeah, and this morning, and I think Yoshi-san has said the in-house counsel make decision, and they need to know the situation, they need to know the environment, and then they could consider if we use arbitration or mediation. And this is I think the second point I want to raise. And I think the third one is confidential. It's good for arbitration and for mediation, because that will decrease the effect for the companies. But because the confidential and nobody knows what happened, and between the two parties for arbitration or mediation, so I suggest like BAC, and you are a very good platform, yeah, and you did a very good job. This is very impressive, yeah, for this book. This is my first time to read this kind of book, and you are a very good platform, and you could host some forum or some workshop, and publish some cases, and you could, no need the confidential information, yeah. But we need to know what happened in this arbitration society or mediation society, yeah. And I'm a little, I just stop here. Thank you.
Thank you. I totally agree with you, because from the feedback from Huawei and also from other tech companies, I feel that the many tech companies are becoming very interested, in arbitration, because because according to your views, the award can be globally enforced against certain counterparties, and also you are value the confidentialities of certain transactions. So that's why you like to choose arbitration to resolve your disputes in some of your transactions, right? And also we understand your concern that because most IP cases are handled by the courts, not by the arbitration institutions, therefore the most IP experts, maybe they are not so familiar with arbitration procedures, and the most, what we call the arbitration experts, they do not have the enough opportunity to handle the IP-related cases, therefore they are unfamiliar with the IP substantive issues. I think for the institutions, maybe this is something we should do, try to improve this situation. Maybe we can, on the one hand, we can provide some training sessions for the IP users to let you know more about the arbitration, and of course we can also try to set up a special panel of IP arbitrators, which can include the IP experts, both the IP experts and also the arbitration experts who are very good at using the what I call the text experts and also the quantum experts for assistance, right, to resolve all the IP-related disputes. I think this is something we're doing. I believe for SIS and also other major arbitration institutions, we believe there is a big potential in this sector. Now I will turn to the Ajumu. Same question. So what is your views about the use of arbitration or the use of arbitration plus mediation in Japan to resolve the IP-related disputes?
Okay. From practitioner's view, it's kind of difficult to use arbitration for IP disputes because major IP disputes are infringement, which is, the nature of which is basically tort, and there is no contractual relationship between the parties. So it's very difficult to have a dispute resolution agreement after the dispute happening. So that's a basic point. On the other hand, in Japan, recently, Tokyo District Court and Osaka District Court started to take IP mediation, and the courts are two major IP courts, and they started to take IP mediation. So far, I don't think they are used much, but this may be a good starting point, because often a case litigation is referred to mediation in the middle of the case hearing. So in that case, if the case fits the mediation, you could get better settlement rather than a lawsuit. So that type of case, from litigation to mediation would be a good chance to use ADR in IP disputes. Thank you.
Thank you. So now I will turn to Hairuo. So as a main speaker for this panel, you have heard all the comments from the users and also from our colleagues in Japan. So I would like to know your views about the arbitration and also the litigation, because you have extensive experiences, in handling all the litigations and arbitrations in China. So what is your views? So which method would you prefer to resolve the IP-related disputes?
Well, thank you for the question, and I'm very glad that David just mentioned that they still, currently they still prefer to go to court to resolve their IP disputes, because I'm a IP litigator and more familiar with the court's proceedings, and also like to point it out that although the litigations before the court is the major mechanism to resolve IP disputes. Nowadays, we see more and more companies choose arbitration to resolve their IP disputes involving IP license agreement, IP transfer agreement, and agreements involving trade secret. And also, I think the Chinese court, they are really willing to help to cooperate with arbitration institutes, because they are super busy. They have a very heavy caseload. For instance, for Beijing IP court judge, every year they need to conclude 400 cases per judge per year. So they have the strong motivation to outsource or to refer some suitable IP disputes to the mediation and arbitration center. And I agree with you that maybe if by having more IP panels and also have more arbitrators with IP background will help promote to resolve IP disputes using ADR.
I think another important issue is about the arbitrability of the IP disputes, because for the leading jurisdictions like Singapore and Hong Kong, they have already revised their laws to allow that all IP-related disputes, can be arbitrated in arbitration procedures. Now, I think China is also in the process of revising our own arbitration law, and Ms. Zhang Lili, as one of the leading experts, has deeply involved in this legislation process. Maybe now it's a good time for us to advise the legislature body, try to make some innovation on this point. Because from our experiences, from all the IP-related disputes handled by SIC, basically it's about the contract disputes. It's about the licensing agreement. However, for some, sometimes there might be involve some issues about the ownership or about the effectiveness of certain IP rights. So I think that situation will sometimes affect the user's decision, on the choice of the dispute resolution. So maybe the best way is to ensure that all IP-related disputes can be arbitrated. I think that will, help more users to choose arbitration as a preferred method of dispute resolution. I think I only have 1 minute. I'll allow all of you to speak maybe last word to the audience. You can speak anything you want.
Well, I think our IP arbitration is a developing and a huge market, and I look forward to litigating, doing cases before the arbitration institute in the future.
Besides the litigation and the arbitration, and there are more and more people go to mediation procedure in China. And I think we could see the co-mediation between China and Singapore and some other countries, but I realized that there is no co-mediation between China and Japan. So I suggest the Japan organization could cooperate with China, and this is a very big market, and I believe there will be good money to get. Yeah.
I think it's important to kind of educate the potential parties to IP dispute to recognize ADR as a good option, and this could be a arbitration association's work, and also practitioners' work. We want to go do that in the future.
Thank you, thank you. Now I think I can conclude this session. Thank you very much.
We will have a coffee break for 15 minutes. Please be back at 15:35. Thank you.
れなんかつけてらっしゃるんですか？つけてない。
いや今もうさっきまでつけてて今外しました。さすがに。
さすがに。
なんかでも一応まだ出席してることにはなってる。
すごいね。学部生教えたりされてるんですか？
学部生も教えてますし大学院も教えてます。
大学院も。
喂。
はい。私も30年目ですよ来年。
そうなんですね。
立教大学。
法学部。はい。でも大学生に仲裁とか教えたりしませんよね。
でも教えてます。
するんですか？
英語の授業もあって留学生も含めたそこだとあれですクロスボーダーディスピュートリゾリューションの授業。
大学生はそんなのいけますか？
全然だからそのなんてどのレベルまで落とすか基本構造としてはアンダーグラディエットとして知っておくべきこととちょっと考えてみると本当に
なるほどね。イメージしないですよね、その学生ですよね。
それまで日本のことしか考えたことない。
そうですよね。
こう言えばそうですよね。結構あなた外国人と結婚するときに名字ってどうだろうそうですよねみたいな。
気づきの多そうな授業でなんか
そうです
面白そうですね。
そんな私
So this is the time to start our session. So please have a seat.
遅れるわけないじゃないですか。
まあもちろんそうなんですけど、そうなんですよ。
だって私だから名札ないもん。私ここにあるけど。
青いのがあったんですよベッド。
確かに。早川が？
そうなんですよ。それでなおさらこうなってないんです。
謝谢领导。
So please have a seat. Okay, so thank you very much. And let us begin session 6. I am Akira Morawaki, will serve as the moderator of this session. I am a partner of Anderson Mori and Tomotsune, and I worked in Beijing for 9 years and in Shanghai for 11 years. Concentrating the many things, including international arbitration. I mainly deal with arbitration in SHIAC, Shanghai International Arbitration Center, as well as Singapore SIAC or something like that. But recently, my concentration is shifted to certain investment transactions and projects where the Chinese companies are investing into Japan. In that sense, the theme of this session 6 is highly interesting for me as well. The theme for session 6 is impact of changes in the international situation on international trade, regulatory barriers, export controls, and economic sanctions. This is a highly relevant topic for Chinese companies seeking to expand overseas, as expressed in a slogan such as 走出去 or Belt and Road Initiative, 一带一路. Notably, last week, the US presidential election concluded with Donald Trump being re-elected, raising the likelihood of intensified US-China tensions. The kick-off session 6, I would like Ms. Xin Yuan to present her report on this topic. Ms. Yuan Xin is a partner at Beijing Huanzhong and Partners, the Deputy Secretary General of the China International Investment Forum, and an arbitrator at several arbitration institutions. She has represented clients in numerous cases involving international trade law, foreign investment law, corporate law, franchise law, and more, bringing with her a wealth of experience in a dispute settlement. So, Ms. Shin, please go ahead.
Yes. Good afternoon, ladies and gentlemen, and thank you, Mr. Moderator, for your kind introduction of me. First of all, I would like to thank BAC or BIAC for inviting us to participate in this year's annual review project, and also thank my colleagues for their support on this report. Following BAC's instruction, we prepared this report in 5 parts. The first part is an overview of China's development in the field of international trade and dispute resolution. In a nutshell, the year of 2023 was not an easy one under the combined impact of escalating geopolitical conflicts, drastic monetary policies, persistent high inflation. The global trade growth weakened significantly. However, under such a complex and severe external environment, China's foreign trade in 2023 has maintained steady growth in scale with quality improvement, showing a strong development resilience and vitality. In terms of the scale, according to the customs statistics, the total value of China's imports and exports in 2023 reached RMB 41.76 trillion, approximately $5.8 trillion, making an increase of 0.2% year-on-year. Besides, the year of 2023 marks the 10th anniversary of the Belt and Road Initiative. China's imports and exports with countries along the Belt and Road reached RMB 19.47 trillion, approximately $2.7 trillion, making an increase of 2.8% year-on-year, accounting for 46.6% of China's total foreign trade value. Both the scale and the proportion have hit the highest level since the launch of the Belt and Road Initiative. In addition, China-Europe Railway Express made 17,000 trips, transporting 1.9 million standard containers of cargo, representing year-on-year growth of 6% and 18% respectively. The Western Land Sea New Corridor Railway Express transported 860,000 TEUs of cargo with a year-on-year increase of 13.8%. The top 3 trading partners of China in 2023 were still ASEAN, EU, and the US. ASEAN has been China's largest trading partner for 4 consecutive years, and China has been ASEAN's largest trading partner for many consecutive years. The international situation in 2023 was unpredictable and severe and complex. China faced unprecedented opportunities and challenges. Against this background, China has firmly safeguarded its national sovereignty, security, and development interest, and actively promoted the international cooperation and exchanges, and also committed itself to building a community with shared future for mankind. The measures China took include the following. First, in terms of the domestic law, China has systematically reviewed its foreign-related legal system, built basic, pragmatic, and comprehensive legal framework for foreign relations, established a foreign state immunity system, and improved the legal system for customs administration and export control. Second, in terms of the pilot free trade zones, China has aligned itself with international high standard economic and trade rules and continuously improved the layout of the free trade zones network. Third, China has played an important role in global trade governance. In 2023, China accepted the WTO agreement on fisheries subsidies, and together with other 90 WTO members, including EU and the US, substantially concluded negotiations on a number of digital trade rules and reached the basic consensus on 13 issues. Fourth, China has been active in signing and negotiation and signing of bilateral, multilateral, and regional free trade agreements. In 2023, China set a new record of signing 4 new free trade agreements in 1 year, and together with over 30 countries, released an initiative on the international cooperation in the field of digital economy and green development. Fifth, in terms of the international trade dispute resolution, given that China experienced a robust expansion in international trade, especially in the sectors of e-commerce and digital economy, various new types of cases appeared. And again, this background, the Chinese courts and arbitration institutions have showcased the remarkable professionalism and case management expertise. Sixth, in terms of the cross-border trade frictions, focus should be given on the supply chain risks, the export control and sanctions, EU's carbon border adjustment mechanism, and EU's anti-subsidy measures against China's new energy vehicle industry. All of these reveal the rising trend of politicization in international trade, the protectionism, and the prevalence of unilateralism in Western countries. The second part of this report is update of laws, regulations, and other normative documents, which can be mainly divided into 4 categories. The first category is about the legal system for foreign relations and state immunity. Under this category, we have 2 laws. The first one is the law on foreign relations, which took effective in July the 1st, 2023. This is China's first comprehensive statute about the foreign relations. It clearly specifies China's objectives in the aspect of international trade, namely, insist on promoting high-level opening up to the outside world, develop foreign trade, maintain multilateral trade system, oppose unilateralism and protectionism, and promote the building of an open world economy. It also consolidates the legal basis for a series of countermeasures introduced by China and clarifies the targets and the mechanisms of countermeasures and restrictions, which can reserve spaces for China to implement countermeasures in the future. The second law is a law on foreign state immunity, which took effective on January the 1st, 2024. It shifts from absolute state immunity to restrictive state immunity, establishing a principle that foreign states and their properties can enjoy immunity in China, while also specifying exceptions to jurisdictional immunity. So following this law related to international trade. The second category is about the improvement of customs administration and export control system. This is a list of the newly enacted or proposed to enacted laws and regulations concerning the custom administration and export control. In 2023, China issued the draft of the customs law for comment. and also issued a series of rules and regulations concerning the export and import control of certain items, including dual-use items, commercial cryptography, technologies, and certain unmanned area vehicles, and so on. So if you want to learn more information about these rules and regulations, you can read our report. And the third category is about the promotion of free trade zones. In 2023, the Xinjiang Free Trade Zone was officially established. And the State Council of the PRC has successively issued documents aimed at aligning with international high standard economic and trade rules and promoting the opening up of free trade zones. The last category is about international cooperation and the promotion of high-level opening up. On June the 2nd, 2023, the RCEP agreement entered into force for all 15 signatory countries. Over the past 2 years, RCEP has brought numerous benefits to Chinese enterprises and together with its free trade partners in terms of reducing tariff, opening up market, reducing trade barriers, and strengthening industrial supply chain cooperation. And also, in 2023, China signed new free trade agreements with Ecuador, Nicaragua, and Serbia, and also signed a protocol to further upgrade the China-Singapore Free Trade Agreement. The third part of this report is case study. In this part, we selected 4 cases dealing with issues usually happening in international sales of goods, including the understanding and application of CSG, the fraud, the trade fraud, the ascertainment of foreign laws, and the dispute in e-commerce. Because of the time limit, I will skip this part. And if you are interested in the 4 cases, you can read our book. And the fourth part of this report is some hot issues. The first one is export control and economic sanctions. In 2023, the US has increased its export controls on China's high-tech sectors, especially the semiconductors items. The US reached an agreement with Netherlands and Japan to limit the export of equipment needed to manufacture advanced semiconductors to China. And the US also continued to list large number of Chinese entities and individuals on its entity list. Therefore, the cross-border compliance risks remain prominent for Chinese enterprises. US economic sanctions activities implemented in 2023 remain active. Russia remains the key target of the economic sanctions by the US. And the US also added a large number of Chinese individuals and entities to the SDN list. In 2023, China also took measures in both export controls and economic sanctions. On one hand, as I said in part 2, China has issued a series of rules and regulations to strengthen the import and export control on specific technologies and products. And on the other hand, in the face of the escalation and abuse of US economic sanctions, China has strengthened its practice of sanctions and counter-sanctions measures. For example, the Ministry of Foreign Affairs of PRC has added the new section, Counter-Sanctions List and Measures, on its website. And Chinese court also provided judicial guarantees for parties to address sanction risk through legal means. The next issue, the second issue, is about the increasing impact of climate change issues on trade policy. In 2023, the EU enacted the Carbon Border Adjustment Mechanism regulation, CBAM. CBAM requires importers to pay an additional amount, also known as carbon tariff, to the EU when importing certain goods produced outside the EU. The payment amount is calculated on basis of the quantity of the carbon dioxide or other greenhouse gases emitted during the production process of those goods. The transitional period for CBAM implementation is set from October the 1st, 2023 to the end of 2025. The industries currently covered by CBAM include cement, steel, aluminum, fertilizers, electricity, and hydrogen, with the scope expected to be expanded in the future. A spokesperson of Chinese Ministry of Ecology and Environment stated that CBAM is essentially a unilateral measure that not only violates the WTO rules, but also does not comply with the United Nations Framework Convention on Climate Change and Paris Agreement. Besides, on October the 4th, 2023, the European Commission decided to formally initiate an anti-subsidy investigation into electric vehicles from China. And from the provisional decision issued in this July, Chinese enterprises were imposed a tariff of up to 37.6%. And also in 2024, this year, the European Commission initiated in-depth anti-subsidy investigations into 3 Chinese green energy companies, according to its newly enacted foreign subsidy regulation. These companies eventually opted out of the bidding, and finally, the European Commission terminated the investigations. And on May 14th, 2024, the US government announced a tariff increase on 18 billion worth of goods imported from China. Specifically, tariffs on electric vehicles will increase from 25% to 100%. Actually, this policy had become effective in September of this year. And it can be seen from all of this that, on one hand, the EU introduced the CBAM system under the guise of environmental protection, imposing carbon tariffs to the products imported from regions and countries outside EU. And on the other hand, while increasing support on its domestic clean energy industries, EU also has taken activities to like anti-subsidy measures against Chinese clean energy industry. This reflects the rising trend of politicization and protectionism of the business environment in EU. In summary, facing such a complex and severe situation, by great effort, Chinese foreign trade in 2023 made a smooth development. However, in the next few years, China still faces numerous challenges in the field of international trade. First, the geopolitical economic relations among major economies are still unstable. And second, trade barriers will further increase, especially after the success of Trump in its election, including not only the traditional restrictive measures like anti-dumping, anti-subsidy, but also the green trade barriers, and as well as the escalating export controls and sanctions. Efforts and explorations are still needed from all economies and sectors of the international community are still needed to establish a more free, stable, fair, just, transparent, and sustainable trading environment through the improvement of multilateral trade rules. That concludes my sharing of this report. Thank you for your patience.
Thank you very much, Ms. Chin. Yeah, that is perfect and outstanding. So what is outstanding is that keep the time, just 20 minutes. So Ms. Shim provided an overview of international issues and export control issues, or mainly from China's perspective, as well as the recent progress or hot topics in China in this regard. Now, let's hear from the commentators. First, we have Mr. Simon Matsuzaki. He is an in-house counsel, has extensive experience in international business in the legal department of Itochu, one of Japan's leading shosha or trading companies, and subsequently served in the legal department of Travel.com, a prominent Chinese OTA. He would provide comments on trade issues and economic security issues from the perspective of a corporate legal department. Mr. Simon, please proceed with your comments.
Okay. Hello, everyone. I'm Simon. I'm a legal counsel of Trip.com. Trip.com is an online travel agency, so which are probably you are more familiar with the name of the C-Trip or the Shenzhen in China, I think. Okay. And so this session 6 are focusing on the sanctions and economic sanction export control. So I would like to highlight 2 points here. The first one is about OTA in the context of the sanction. And also I would like to introduce a Japanese leading case, which is really old, but the Qualcomm Toshiba case. So let me begin with the first point here. So OTA is OTA provides accommodation services, booking or flight booking services, or any other travel-related service or products on their platform. So in the context of the sanctions, if you can probably imagine that, so if the OTAs want to provide the hotel products, and the hotel is located in like Cuba or Russia or Iran or any other countries or region under sanctions, it's really, we need to consider whether we can sell such products on our platform. And of course, the first point here is to, from legal perspective, whether it is okay to sell such products or not. But also, we need to consider other factors, like from the PR, public relation factors, like whether how the consumers see or perceive our attitude or stance towards such products. And also, we need to consider about the relationship with the foreign governments or its embassies. So when we decide to sell such products on our platform, so we need to balance these factors. So balancing is really essential for us when we sell such products. That's all from my comments on first one, OTA. And secondly, I would like to introduce this leading case, Qualcomm Toshiba case. Qualcomm was a key framework of the export control among the US and several European countries and Japan. And so 1987 was still the Cold War era. And this Qualcomm was established to control export of strategic goods and technology to Soviet Union and its allies. So in such a situation, what happened in Japan in 1987? Toshiba is a General Electric Machinery company, in Chinese, Dongji. And the subsidiary with Toshiba exported its machine tools through a trading company to Norway firstly, but finally exported into the Soviet Union. And the machine tools were general technical products, but they were used to reduce the screw noise of the Soviet nuclear submarines. So, of course, you can easily imagine the US government got really angry about this. And so what happened and what problem did this case cause? Of course, there was a criminal liability, so 2 executives of the subsidiary were arrested and charged. And also, the Toshiba, parent company Toshiba's 2 top management were forced to resign. And also there was diplomatic issues, so US government banned the import of Toshiba products, and this case strained the US-JP diplomatic relations. So this case was a really big impact on Japanese companies, especially trading companies. So before this case, there wasn't a concept of compliance in Japan. So we didn't use that word in the business context, but because of this case, we started using the word compliance. So a lot of trading companies started setting internal department to deal with the sanctions, export control matters. So currently, as far as I know, Japanese trading companies, most of the Japanese companies have really sophisticated internal procedure and mechanisms to check and control the export controls matters. So I think that they can, as long as the matters are only related to Japanese regulations, they didn't seek the Japanese law firm support, so they can independently resolve such matters. But also, they are really keen, and they really understand the importance of the recent information and the recent trends. So they are really closely communicating with foreign law firms to update their knowledge and understanding. That's all for my comments. So thank you for your attention, and let me give back my baton to Moriaki-sensei. Thank you.
Thank you, Mr. Simon. The Toshiba Kokomi incident that Mr. Simon introduced is indeed an old case back to 1987. But since Japanese companies have rarely faced severe penalties in trade matters, this incident still serves as a kind of trauma for Japanese major corporations. It is also noteworthy as it relates to the ongoing dual-use issue, which frequently arise in recent export control regulations. I encourage all lawyers from outside Japan to remember this Toshiba Kokomi case, as it is the case that every legal professional in Japan is familiar with. So next, we have Mr. Yoshi Hayakawa. Many of you probably already know Yoshi, and he needs little introduction. He's a professor of Rikyo University, one of Japan's prestigious private universities, and is also a lawyer with extensive experience handling arbitration cases and giving lectures worldwide. Professor Hayakawa, please proceed.
Thank you very much. And let me explain about the changes of attitude toward international trade law many countries. So let me explain about the recent change of the United States. So many of you know about the WTO dispute settlement body is not working now because the United States has continued to block the appointment of the new judges to the appellate body by the United States. And in September, I remember the US raised its tariff rate against several products from China, 100% for EV, and 50% for solar panel, and 25% for steel, aluminum, EV battery, and major mineral products. State of Florida recently established a restriction against the sales of real estate to Chinese or Chinese companies for the purpose of protecting national security of the United States. How about EU? European Commission, I heard, is now preparing the additional raise of the tariff rate against the products from China. How about others? For example, Indonesia. Indonesian government has not yet recognized, for example, the operation of a famous Chinese e-commerce vendor, Temu. So these are only just examples, but the free trade, or concept of free trade is not the most important interest in the international trade law for them anymore. Why? That is because the most significant incident for the change is, of course, the rise of economic power of China. And the economic power balance has been changed between China and other countries. And additionally, economic changes or economic situations in the society of each state or each regional group of state have been already changed. How changed? And what is the impact? You know this person. And just we have received the final result of election of the next president in the United States. As you know, Donald Trump will come back. And he is, of course, not the guardian of free trade. And the right side person, he is a crazy supporter or typical supporter of Donald Trump. But at the very beginning, I did not understand why barbecue beer freedom. But finally, I realized that is a kind of the typical ordinary people in the United States, especially they are living in the so-called Rust Belt area, and they used to enjoy their life. Weekday, they work hard, and weekend, they enjoyed barbecue and beer and rock and roll. But unfortunately, this kind of the tiny happiness will be in their mind destroyed by the present free trade or impact from China. So that is the reason why they try to appoint someone who may change, of course, may change something. And perhaps, Donald Trump is, as you know, billionaire. They have never considered such kind of the ordinary people, but ordinary people, unfortunately, have to have a kind of the dream that is not, I believe that it is not real one, but they dreamed, the president, next President Trump may change something. And the concept, important concept they are now using is national security, as I explained in the Florida state, the examples. So the national security has been used in the many free trade, the agreement or some others, and it's a traditional concept. But until recently, we did not interpret this concept so widely or broadly. But now they try to interpret this concept very wide and try to use kind of the tool or weapon to block the free trade or to block importing something from China. So that is a very, the typical change in the United States. But how about EU? I have just come back from Paris yesterday, and I saw many electric vehicle buses are crossing in front of famous Eiffel Tower. So that is a present situation in Europe. So the European countries now shifted their own vehicle industry from the gasoline ones to the EV, electric vehicles. But samely, the China changed this direction, and the Chinese reasonable price and good quality buses are now coming to European area, and I heard Volkswagen is now struggling with the very bad the situation, economic situation, and they have to close many factories, and it means that they have to fire many employees. So the European unions also have similar problems, but that due to the impact of China. But that their tool or legal weapon is a little bit different. For example, do you know the recently established Human Rights Due Diligence Directive? So any European company or the foreign company doing business in Europe are obliged to check every single, the relationship with their counterparty, upstream or downstream, and try to check their behavior in relation to the human rights. And human rights including the protecting environmental conditions. So the pollution should not be, provided, in relation to the concept of human rights. So that is a new directive. And it means, that many European company or Japanese company doing business in Europe have to care about the relationship with the foreign company, including Chinese company, and whether or not these company might have a kind of for example, very severe environmental, the labor conditions, or the environmental, the pollution problem, something like that. So that is another change of the Europe. So that is the change of the attitude why they are now facing the many problems, and this is the source of the problems. So I'd like to emphasize. So now the economic situation or other situations are drastically changing, around China, of course, around Japan, and we have to explore the kind of the solution. Otherwise, we will have to face a much more serious problem. So that is my contribution. Thank you very much.
Okay, so thank you very much, Toshi. And Toshi's perspective is very interesting. For me, the current situation seems very strange because almost 20 years ago, when I start working in China, so most of the Western countries, including EU or the United States, strongly request China to follow the free trade principles. So, but in any event, so before the conclusion, so please, Ms. Xin, to make some brief comments from the Chinese side.
Okay, thank you. I will give a brief comment and on 2 points. The first point is about the export control and economic sanction. Simon shared Toshiba incident. Actually, in China, we also have a similar case, ZTE incident. In Chinese, we call it 中兴事件. This incident was occurred in 2018. At that time, Zhongxin was accused of violating U.S. export control law by selling goods to Iran. And ZTE suffered a lot of losses at that time. But recently, from the public report, I've found that Zhongxin has turned from losses to profitability, mainly because of its establishment of compliance management system. And it also developed a system for the digital system to help other enterprises to manage the compliance risk. And I also found that some of the enterprises had purchased this system, and its effectiveness deserves our further attention. This is the first point. The second point is about the Mr. Hayakawa shared some development in EU and US and Chinese enterprises, a good performance in those areas. And we also know that the Western countries accused of China overcapacity in these areas. But actually, it is not true because the basic of overcapacity is that the supply cannot exceed their domestic demand. But actually, we can say the Airbuses and airplanes manufactured by EU and US are also supplied to all over the world. Yes, so that's because I think that's because the basic principle in the free trade the comparative advantage theory initiated by Mr. David Ricardo, an economist 200 years ago. So from this principle, the countries should engage in the division of labors and international trade on basis of the comparative advantage. And under such circumstance, all the countries can get benefit from this cross-border trade. From this, I think the good performance of Chinese enterprises is not because of the so-called low price sales resulting from overcapacity, but from Chinese enterprises increased competitiveness in terms of technology renovation, high production efficiency, and the brand influence. That's all. Thank you.
Okay, so thank you very much. That's very interesting, and maybe the discussion should be should need much more time, but our time has already finished. So with that, we will conclude session 6. So thank you very much for your attention. Thank you very much.
8分過ぎたところで、あと1分で出たので、もう少し話しましたけど。
大丈夫です。
写真撮る。Okay.
Thank you. Thank you. Thank you very much.
Thank you very much. Thank you. Thank you.
Last comment is very nice. Let's go.
Okay. Thank you, everybody, for staying with us until now. I'm Helena Chen. My special thanks to the organizer for having me this afternoon. And I'm also very happy to share this panel with our outstanding panelists. They are truly the experts in the field of construction arbitration. We firstly will have Ms. Meng Yao to report on these international construction projects under the Belt and Road Initiatives, risk identification, and the management measures. She will be speaking in lieu of Mr. Cui Jun, who unfortunately would not be able to join us owing to some very last-minute coincidence happened beyond his control. Meng Yao is actually an old friend of mine. She is the senior partner of Jindu law firm based in Beijing, and she is also currently the Deputy Secretary General of the Legal Service Working Committee of the China Construction Industry Association. Without further ado, the floor is now yours.
Okay, thank you. Thank you, Helena. Hello? Okay. Thank you, Helena, for your nice introduction. Okay, good afternoon, ladies and gentlemen. I'm very delighted to take part in this 2024 Tokyo Summit on the commercial dispute resolution in China. It's a great opportunity for me, but I think it's rather more than a challenge because I just got this task yesterday. Okay. Now my topic is international construction projects under the Belt and Road Initiative, risk identification and management measures. Okay. There are 4 parts in my slides, and first we will talk about some data and information from Chinese international contractors' perspective. And in 2023, the turnover of China's overseas contracted projects have reached 160 billion US dollars, an increase of 3.8% over the previous year. And the value of new signed contracts have achieved more than 260 billion US dollars, up to 4.5% over the year of 2022. Here, we'd like to show some key features of the latest practice and the new trend in Chinese international construction projects. The first one is the construction dispute is shifting from traditional construction contract into EPC and the design-build contract. And then construction disputes is arising from new energy sectors such as solar power, wind farm, energy storage, and so on is becoming significantly increasing. And in addition to the typical disputes like payment issue, LD is means liquidated damages, variation and extra, security, fraud, corruption, and the sanction issue become apparent in recent years. And here we want to stress that these new trends pose 2 new challenges to management and the abilities of construction companies. Why? For example, the traditional construction contracts, as we all know, is FIDIC Red Book. The most important character of a FIDIC Red Book is it contains 2 key items: a bill of qualities, and the construction drawings. While in EPC and the design-build contracts, they don't have these 2 key items, but they have other important documents like the employer's requirement. Therefore, higher requirements are placed on the contractor's design and management abilities, and it will also increase more dispute. Okay. Next one we'll talk about is the main content of my slides, risk identification. And we can see from the chart there are 3 types of risk: environmental risk, market risk, and contract and legal risk. And it's obvious the environmental risk is fundamental and has the most widespread influence. Okay, the environmental risk, it contains mainly the 3 types: the geopolitical risk, inter-regional war risk, and the sanction risks. And we'd like to mention more about the Russia-Ukraine war. It is well known for everybody, and this war is triggered global trade impacts, which are reflecting aspects such as funding, material and equipment supply, and schedule management for engineering projects. These factors actually certainly have a certain impact on the cost of and the price of the project. Now we come to the market risk. Nowadays, as I think we know that the most relatively good, not most, relatively good region is the Middle East market. And we think market competition mainly manifests in low price competition, labor supply, currency devaluation, and inflation. And in practice, market competition depends on local resources. It's very important, the local resources. And the headquarter platform resources means the construction company itself is headquarters, and the management capability of construction companies, such as whether there are sufficient local projects, local suppliers, labor, and extra. Somebody would ask that it is not unfair for a new company to enter into a new market. That's right. In this case, you have to make more cooperation with local resources, with local companies to get more projects and suppliers and so on. Okay, now we come to the contract and the legal risk arising from EPC and the DB model, design-build contract. We list 5 aspects of the more disputes arising from EPC and the DB model: the scope of works, construction quantities, design obligation, employer's requirement, and the variation. The key points we want to mention here is that requirements of changes of the employer. In fact, changes of EPC contracts usually come from changes requested by the employer, rather than from the construction drawings itself. In practice, the employer requires a specialized document that clearly defines the functions, durations, and the technical standards of the project. And often we might see this facts that there may be some ambiguity in the building documents of the employer. If the contractor may not raise any question when they are bidding, then it can lead to misunderstanding in the scope of the project, design obligation, quantity of work, pricing, and other aspects. Then it will cause disputes in the future. This slide will show focus on the claim deadline. This is a common issue, mainly referring to the time bar, and I will quote the words from the provisions. If the claiming party fails to give a notice of a claim within the period of 28 days, it shall not be entitled to any additional payment. The contract price shall not be reduced. Okay, it is known by everybody. And we want to stress here by 2 points. The first one is whether there is a fault on the part of the employer that prevents the submission of a claim notice from more than 28 days. Second, it is about whether the parties involved to have reached a new agreement and uniformly delayed the submission of the 28 days. This is relating to the contractual risk arising from strict contractual provisions as well. And we have listed 6 aspects of sharing risk. It contains the first one, accuracy, correctness of employer's requirement. Project data information is treated as a reference. And the third, no entitlement to claim EOT and additional cost. And the fourth one, high liquidated damages for delay and backloading payment milestone and assessment on the completed works value at termination and lump sum contract. Okay, I think somebody will say that it is unbalanced risk allocation, while we don't think so. We think it is the construction company's obligation to value to value your project, you have to see your project data, your information by yourself. It's not the employer's duty to give you all the material, all the data, all the information of the project. Next part, we will talk about the construction disputes in new energy, like I said earlier, the new energy sector, and we list two main. The first one is the solar power sector, and we'd like to ask you to pay attention to the efficiency of power generation and the quality of modules due to environmental factors like sunlight, temperature, climate. And the wind farm sector is has a similar elements like the road survey, road modification, and internal road design and the construction with the wind farm. This part will focus on the risk management measures. And we think the first one is most important is the contract plan. Make a good contract plan, including funds, labor, material, and equipment, construction machinery, foreign exchange, legal investigation, and extra. And secondly, you have to have strict control of project management, including cross-operation, change, and revision of project schedule plans. And third and fourth, you have to come to the claim, and you have to make a good claim notice and have a good claim report. And I think it's a little bit complex. We will not say more details here. Okay, come to the last, we will talk about the risk management is dispute resolution. And we have listed 3 ways the effective management of uncontracted disputes, of course. And you have to go to the dispute adjudication board or the dispute board and the last, the arbitration case management. And we would seek help from our arbitration institution. Looking forward to 2022-2024, the number of construction dispute cases will remain at a high level. Arbitration has become an important dispute resolution for parties to solve construction disputes at home and abroad. Chinese arbitration institution will certainly be more deeply integrated into the dispute resolution of international construction projects. That's all my speech, and thank you for your listening.
Thank you very much, Mo Yao. I think you just accomplished the mission impossible to familiarize yourself with this very comprehensive report in such a short period of time, and then to brief us in such clear and concise terms. I will now invite our co-panelists to comment on this report. Firstly, I would like to invite Mr. Sharaz Mian Javed. He is currently the chair of the Pakistan branch of the Chartered Institute of Arbitrators. He is a highly experienced barrister with more than 20 years of experience, leveraging his background as a civil engineer with a specialization in construction and energy disputes. Mr. Javad, please.
Thank you very much. Good evening, everyone. And thank you so much for being here for the last session. Usually this last slot is known to be as the graveyard slot. It's really difficult to be awake up until this time. Thank you very much for the ladies and gentlemen, and also I'm grateful for Beijing International Arbitration Center and other organizations for setting this excellent panel, and for this about the overview of what exactly is going on in China for last year. Since we're going to talk about the risk management and identification in the construction sector, just to give you a brief overview of what has been expressed previously in the report. From post-pandemic growth, I think it's 5.8% increase every year, which is persistent. Last year, it was 5.9% in 2023. The persistent dispute factors, they are almost the same as project costs, completion settlements, and liquidated damages. And besides that, the real estate downturn, debt defaults, and bankruptcies are also contributing to the dispute factors. We have also seen the internationalization of institutes like BSc and CTAC, and it's really amazing to see that BSc handled over 200 international cases last year. And this is also something which is really close to my heart as well, since China has invested more than $100 billion for the China-Pakistan Economic Corridor, and all these disputes, which are predominantly from infrastructure and power sector, they are about to emerge and they're about to enter into the arbitration phase. So we are still looking around of this internationalization of these institutes and how these institutes can help in resolution of the disputes through arbitration. And then we have also seen the emergence of dispute adjudication boards, which have, like we can see from the report, that they have been proven effective in resolving construction disputes in China. And in international projects, since from 2017 FEDIC Red Book, that actually promotes not just DAB, but also dispute avoidance and adjudication board, which in my opinion is one of the key factors that allows the construction projects to finish well in time. And then coming on to the risk management and identification measures, the crux of the report, that we need to look into the effective management of contract disputes and dispute adjudication boards which are being used. And the report also highlights the arbitration case management. Also, this arbitration case management is something which is really important in terms of developing procedures in a more concise manner. Of course, the dispute board has been highlighted in the report, but since I'm going to give a couple of suggestions which, in my opinion, in my experience, are important in order to get these construction projects, specifically the projects related to the construction industry, to finish in time. So I think I've got two-pronged suggestions for this for China's construction sector. One is about the dispute avoidance. We are talking about dispute resolution, and we have seen how the disputes are being resolved once the dispute has been crystallized. But what about if we are able to avoid the dispute, or maybe the emergence of the dispute? And how effectively can we do that? And what are the benefits that can be drawn if we are able to successfully avoid the dispute? And there's a famous quote that avoidance precedes resolution. So we, at the first place, how about incorporating the strategies, the mechanisms that can effectively safeguard the dispute from emergence? And then if for some reason we are unable to avoid the dispute, then how about adding up the dispute resolution protocols? Instead of just jumping into the arbitration, are there any such methodologies that can be incorporated in terms of efficiency in time, and efficiency in cost as compared to arbitration? So when we talk about the dispute avoidance methodologies, I think the most important element is to either have a dispute adjudication and avoidance board, what we call DAAB, or I'm really fascinated with the idea of having dispute resolution advisors which is a popular terminology in Hong Kong, where a project of a certain size is required by statute to have a dispute resolution advisor since the inception of the project. And it not just only deals with the dispute resolution, but also we can give the mandate right from the planning stage. For example, the dispute avoidance board or the dispute resolution advisors, they can work along for the risk management plan. They can identify project risk and assign the management to the best suited parties. So they will not only talk about the risk mitigation and risk transfer, but they will also talk about the risk profiling and the risk outlook of a project. Since if we talk about the Belt and Road Initiative, there are around 65 countries which are involved in the whole system. There are difference of languages, difference of culture, and there are different political situations in different countries. So we do need to develop not just the risk profile of what are the risks which are available in those specific countries in terms of their region, but we also need to develop the risk outlook, which means that not just the current risks which are available there, but we also need to develop the future risks that can emerge in these areas. And when we talk about 65 different countries, so what is the best way of, you cannot develop a single size that can fit all. We need to have a mechanism which is dynamic. And for that, I think a dispute board, a dispute avoidance board, or dispute resolution advisors having 3 members with one from each country, and one, they can have a chair for that. They can have a flavor of the cultures from both sides, since they will understand the language and then they will understand the culture, and then they can advise on the project of how to navigate the project from different stages, from pre-planning partnering, right, starting with the designers and engineers. The new terminologies which are coming up in the construction sector is about the collaborative contracting. For example, PPC 2000 is a new standard form of contract that allows the parties to involve right at the very early stage, where you have yet to start with the planning. So you can have the contractor involved at the planning stage as well, which actually identifies and provides a platform of collaboration to reduce the potential disputes. And then they can develop the communication plan. They will have partnering sessions right from the startup up until the end of the project. They will have document review. They will identify the risk, and then they can give those strategies of how to avoid them while the risk emerge. And then if they are unable to manage those things at that point of time, then they can work on the dispute escalation chart, just in case the dispute arises. And they can also talk about those on-site ADR techniques, from like the new explanation or the new meaning of ADR from alternative dispute resolution is now converting into appropriate dispute resolution. Not every dispute is feasible for mediation or arbitration, and all these elements that can be supported by this, the role and the idea of the dispute resolution advisor or the dispute avoidance board. And once the dispute cannot be avoided, and it has reached to a point where, besides all the contributions of the avoidance board, it reaches to being crystallized, what we can do is we can incorporate certain dispute resolution protocols. Just like we can have pre-litigation protocols before you enter into the court, you have to have some form of alternative dispute resolution. In the same way, once a dispute has been crystallized, before the arbitration, we can have different mechanisms like party-to-party negotiation, mediation, and amicable settlement formations that can be added into it. Since we have seen a number of presentations today, the contract language is very important. We understand that. It should be simple. That's all right. The contract is the key document. It's the holy document for the rights and obligation for both the parties. It's not just about the language being simple. It's the negotiations of the terms are also very important, which should be done mindfully. It's not just about picking up a standard form of a contract, but it also requires the experience And it's not just the business terms which are important. The dispute resolution methodologies are also becoming increasingly important, especially for international projects like the project for the Belt and Road Initiative. And I see a disconnect between the business teams and the legal teams, which is why the legal teams are not consulted at the time of negotiation of the business terms. But these dispute resolution clauses, they need to give that importance in terms of we can have multi-tier dispute resolution clauses. And in case we are adopting FDIC Red Book or FDIC Yellow Book, the dispute resolution clauses can always be replaced with the with your customized dispute resolution clauses, which I think is one of the important element. And then while having these customized dispute resolution clauses, the multi-tiers should be properly addressed according to the need and requirements of that specific project in different regions. So these are my suggestions and comments on the construction report. Thank you.
Thank you very much for this very insightful comments, especially I think a rather clear introduction to those other alternative dispute resolution methods that the parties may take into consideration before arbitration. And then I would like to invite Mr. Daniel Allen to comment. Daniel is a partner of Mori, Hamada, and Matsumoto. Daniel is also an international arbitration specialist. His leadership in the Japanese international arbitration market has already been recognized by the chambers, Lexology Index, the Legal 500s, and many others. Daniel, the floor is now yours.
Thank you for that generous introduction. I think I wrote that, and it sounded really pompous, so I'm sorry about that. I guess I'm the last speaker, the last substantive speaker for today, so I will do my best to be brief and incisive to the best of my ability. I found this report particularly interesting because I spend a lot of my time these days and over the last few years working on international construction arbitrations. It consumes a lot of my mental energy thinking about these cases. I've worked on a number in Japan. My practice focuses on Japan, but also for Japanese contractors working abroad. So I've seen it from a variety of different angles. There are two points that I wanted to highlight from the report. One is the focus on supply chain issues. I think particularly in the context of renewable energy construction projects, supply chain has become kind of at the forefront in the cases that I've been doing. I don't mean to downplay the technical challenges, engineering challenges that arise on renewable energy projects, but in a lot of cases, you're talking about installation of equipment that needs to be brought in from abroad, and that's the kind of core of a lot of renewable energy projects, particularly solar projects. And so the supply chain is actually the most kind of important link and the most important driver of whether the project can be completed successfully on time and without disruption. So a lot of the cases that I've been doing involving Japan have actually focused more on supply chain than anything else. In particular, a lot of COVID cases arose over the last few years, and many of those COVID cases were actually supply chain cases. COVID issues caused the supply chain to be disrupted. Actually, in Japan, maybe many of you know this, but in Japan, it wasn't so difficult during COVID. We didn't have mass lockdowns, and so construction projects could, in principle, proceed almost as normal, except that the supply chain was disrupted. And so, to the extent that we had COVID-related construction cases, those were mostly supply chain issues. So, that part of the report really resonated with me as a Japan-based practitioner. The other thing I wanted to emphasize or maybe add to the kind of Venn diagram of risk areas, there was contract risk, there was environment risk, and then there was market risk. Okay, I got that right. The one I would add, maybe it fits into environment risk pretty well, but I like to think about it a little bit separately, is regulatory risk. I think that is a particular concern for renewable energy projects, and we've seen it again and again around the world. Renewable energy projects usually have as a core of their business case some sort of governmental subsidy or program that the renewable energy project is going to try to tap into. And what we've seen over the course of the past decade or so is that governments adopt subsidies that are very attractive, and then a lot of investment ensues, often foreign investment, but then those subsidies may not be maintained, or they may be modified due to other considerations that come up. Governments may change, that kind of thing. The most notable and most kind of well-known example was Spain. Saw a massive investment in the solar and wind sector in the kind of early decade of the century, then changed their regulatory environment for feed-in tariffs, which was at the core of the economic model for all of these projects. And then subsequently saw just an absolute deluge of investment arbitration claims against the state, many of which Spain lost. I know this is a topic that's very near and dear to my heart because I worked on one of those cases for a Japanese investor, an ICSID claim against Spain for a wind energy investor. But there were a number of those claims. Several Japanese investors actually ended up bringing claims. It's the type of claim that we've seen Japanese investors involved in the most, these renewable energy claims. So I think any renewable energy project, when you're thinking about risk, you have to also think about that regulatory risk. And I think that probably falls within the broader category of environment risk, but to me it's a distinct enough category with a kind of a distinct enough response that one might want to separate it out and conceptualize it differently. So then I want to end with two comments about how the kind of recurrent problems that I see in Japan-specific projects, and I'm not sure whether these are problems that Chinese companies are also seeing or that are prevalent in the Chinese market, but anyway, I just want to share my experience. So one important problem that I see over and over again is that for Japanese projects cited in Japan, it's typical to use contractual forms or contractual documents that have been prepared kind of by common law lawyers with common law concepts in mind, but then they have a Japanese governing law clause slapped on at the end. And in my experience, that leads to no amount of difficulty in terms of interpreting the contract and trying to apply, reach a resolution through applying the interpretive principles that you have to apply under Japanese law. There's an additional element of confusion that arises, particularly in the context of international arbitration, because you then often have international arbitrators who may know nothing about Japanese law, may know nothing about civil law, nonetheless trying to interpret a contract that is this kind of Frankenstein hybrid of common law and civil law principles. It comes up in almost every case I do, and to the extent that it's helpful, I think it's probably a good idea for companies involved in these projects to think carefully about whether that's the right way to approach things. The second point I'd like to make, and I think this is directly relevant to both the report and also Shiraza's comments about dispute avoidance and the importance of clear contractual language, particularly around claims and when claims need to be made and when they need to be notified and so on. It's a fraught topic here in Japan and dealing with Japanese clients because the Japanese construction industry, the domestic industry, which is extremely well developed, extremely sophisticated, and you can just look around and see that it's extremely active. Basically in Japan, we like to tear buildings down and rebuild them every 10 years or so. So there's constant activity in the domestic space. The usual practice is actually for construction relationships between contractor and employer to be based on trust and a kind of a mutual expectation of cooperation. And it's not that common for Japanese parties to make claims during the course of a project. They tend to carry on and then assume that things can be resolved at the end through kind of good faith discussions. And in practice, that usually works in Japan. But in my experience, Japanese parties involved in international construction projects tend to imagine that same dance will play out in an international project, but often are disappointed in what they find actually happens. And so that level of cultural difference, I think both of you mentioned kind of the importance of tailoring your legal relationships mindfully of kind of cultural expectations and considerations. I think particularly in the case of Japanese companies, a lot of attention needs to be paid to that because their expectations may be radically different from their counterparties. So I think I came in under time, and so that's all I have to say. Thank you.
Thank you, Daniel, for sharing your observations of this recent market. I think our reporter have a last word for us.
Yes. The time of the seminar is short, and the prepare time for me is short as well. But I think because we have taken part in so many legislation and textbook model tax in China, we have taken part in so many activities in China, and we have deal with so many arbitration and litigation cases in China. So I would like to invite all my dearest guests and friends to Beijing, and we can have some more opportunity and chances to talk about, to discuss about the construction projects dispute resolution. Thank you.
Thank you. Thank you.
Thank you.
Thank you. Thank you.
Okay, good afternoon, ladies and gentlemen. Thank you all for staying with us until the closing section. I promise this is definitely the last section. Today, we are very fortunate to have Dr. Lars Markert, the co-chair of IPBA's Dispute Resolution and Arbitration Committee, to deliver the closing remark. I'm sure Dr. Markert needs no introduction in the arbitration community of Asian Pacific regions. So please join me in warmly welcome Dr. Markert to deliver his welcome address.
All right. Thank you very much. Ms. Secretary General Jiang Li and past president of the IPBA, Jack Lee, and of course to my old friend Fuyong Chen. It gives me a great pleasure to give the concluding remarks. If the prior session was the graveyard slot, I'm of course wondering what my slot is, maybe the Nirvana slot or something. So I'll do my best nevertheless. So first of all, I'm particularly happy to be here because it's been a couple of years already before the pandemic that actually we did organize an event in Beijing. I recently had the honor of joining the panel of arbitrators of the Beijing International Arbitration Center. So this is an event that was dear to my heart, and that, of course, we were also happy to support from the IPBA. I can also say I managed to reactivate my WeChat account that somehow had expired over the pandemic, so I'm open for business again. I think this was a great event today. It was great because it really gave us an insight through the reports of what is happening in China and what the thoughts are in China, something that's not so easy to come by. And we got it delivered to us in Tokyo, speaking as somebody living in Tokyo. So that was a really good opportunity. And then, of course, it was organized in a way that we had panels with other international speakers that then were able to share the view from Japan and from other jurisdictions. And so I think that gave a very good mix. Now, from that mix, I took away some differences and some similarities. Differences, I realized in China we have the litigation and arbitration explosion, as one of our speakers called it. And there was a suggestion that mediation should become its own self-standing mechanism rather than an annex. Now, if we compare this to Japan, we poor disputes lawyers need to really hunt for our cases because Japanese companies are very prone to settle and prone not to dispute so much. So I think the landscape is a bit different. Just to give you some figures, I think we heard there are hundreds of thousands of arbitration cases if you group all the arbitration institutions together in China. In Japan, if you somewhat unfairly use the case numbers of the leading Japanese arbitration institution, that's more about 30 cases per year. So there is quite a difference. And we also heard from one of our Japanese speakers that arbitration in commercial matters is actually not, mediation in commercial matters is actually also not used that much, which sometimes is a bit striking when you think Japanese also should be prone to agree and settle. In my experience, that is a bit due to the fact that Japanese companies often say, if we were not able to settle disputes on our own, then initially mediating doesn't really help us. So I think one of our speakers pointed out that sometimes mediation actually makes more sense once the dispute is a bit further advanced and the parties know a bit more about the position of the other side. Final joke about the differences. It seems that when Japanese use AI to generate an image, they become a robot. It becomes a robot, an Ultraman. In China, it becomes a pretty girl. So that was also quite interesting to see. Now, coming to the more important part, the similarities I noticed today. I think one of the main similarity, and I'm happy to say that coming from Germany, Japan and China are, of course, civil law jurisdictions. And in that sense, they are already naturally close in the approach to legal solutions. I think our moderator in the morning called it not colonial jurisdictions. Not sure we need to use that particular wording, but there is a legal similarity. But what was also pointed out this morning, there is a cultural tradition of harmony. And I think that describes it quite well. And so that is a very good basis to collaborate. What is also interesting, we heard this morning, is that there's a desire in both countries to modernize arbitration. And there are actually a lot of stakeholders working together to do so. So in Japan, it's the Ministry of Justice, the JCAA, the local arbitration institution. We've heard there was a modernization of the foreign lawyers law that makes it easier to arbitrate cases with an international element. And we're going to have next week the first Japan International Arbitration Week. Now, when we look to China, we learned that just last Friday, basically the second version of the Chinese Arbitration Act was promulgated. So I think that's going to be interesting. Mr. Fei Ning asked me whether I had read it, and then I asked him back, well, is it in English? And he said, no, it's in Chinese. So I said, no, I didn't. But we'll get there. We'll get there. I'll read it somehow. Of course, we have in China, we heard modernization by the institutions. So a lot of institutions promulgated new arbitration rules. Examples are Hong Kong International Arbitration Center, the BAC new rules. And of course, we're here today and experiencing the first summit in Tokyo. So again, quite a lot of push to modernize. I think what's also common in both jurisdictions is the proactiveness that is used in arbitration as an advantage. One of the examples we heard today is, for example, the use of ARP-MET-ARP. A challenge both jurisdictions face, similarly, is language. that's always going to be a struggle when we compare it to Asian jurisdictions that naturally are English-speaking. So I think both jurisdictions need to make extra efforts to ensure that everything they have can be seen outside, and so there's a lot of translation effort and education effort involved. Now, going on quickly to our various panels, just some takeaways. I think, and I'm looking at this from an arbitration practitioner, I think that the most dispute-prone topics we heard about today, and where arbitration is already the most established, is the field of renewable energy. That was our first session. And I think the last session, construction. And interestingly, those panels, when I look at it from the arbitration perspective, they also overlap to some extent, because we heard in the construction panel, renewable energy is one of the large sectors where everybody sees growth and issues. When we look at the energy transition, of course, we face a couple of classical issues, such as changed circumstances, delay. We heard about supply chain issues that are recently quite common. And of course, good for us disputes practitioners, bad for companies. We have what we heard today, Trump 2.0. That will probably also have a certain effect. Now, and then we heard about a couple of industries where there's a lot of potential, but arbitration is not yet the common method of resolving disputes. So we heard about finance disputes, IP, and then international trade. So in finance, I think we'll still have a lot of court cases, but it was interesting to hear that there's a movement towards mediation and potentially towards arbitration, not least because there are already specialized institutions such as Prime Finance, which is based in Europe, but is really a global institution for settling financial disputes. In IP disputes, we heard that, of course, arbitration struggles because a lot of what makes IP disputes is basically either tort issues or basically administrative regulation of validity of patents. So we'll always go up against arbitrability. Do we have an arbitration agreement? But nevertheless, I think if we carve those issues out, IP is a growing sector, and so I would suspect the arbitration around IP is growing with that as well. And to our friend from Huawei, of course, if we can have hundreds of thousands of patent litigations, we can maybe throw in a couple of arbitrations. Not necessarily about validity of patents, but we'll find something. And we'll provide the lists of arbitrators. Maybe on that note, one comment. There is the Tokyo International Arbitration Center, which is actually specialized in IP disputes and has a roster of international IP judges, I would almost say. But we should check whether they already appropriately added also Chinese practitioners. We'll have to check that. Now, the most I felt somber panel was international trade, where we heard about sanctions, tariffs, countermeasures, and of course, it's a very politicized area. As a European, I'm not going to make a rebuttal, but I think it's a very complex system. I think interestingly, the upsides we heard is, yes, maybe it helps to establish compliance systems. So companies can actually get better at what they do. Something that maybe wasn't so discussed, but that's my impression is, well, if you're cut off from certain things, companies also become self-sufficient. They find new ways to develop, and I think China is a prime example of that. But now to move away from the politicization and to come back to arbitration, I liked a comment that was made this morning. It's if we leave a bit the high level, and we come back to the individuals, like us in the room, I think it's very easy to forge collaboration, mutual understanding, and mutual appreciation. And I think that's where we need to start, and then hope that this trickles up actually into the higher levels. And what was repeated often today was, how do we build bridges? And I think that should be the focus and the takeaway of today's conference, building bridges. There were some interesting suggestions for collaboration, particularly in the area of mediation, to say, well, why don't we have specific Japanese, Chinese mediation platforms for e-commerce, for example, or a co-mediation protocol, something similarly what has been used already in Japan with Singapore. I mean, that should be also possible for Japan and China. And now thinking to our last panel, if we have DABs, let's make sure we have somebody from China, from Japan, if these projects allow for that. So I think there's a lot of avenues for building bridges. I invite you all to think about how we can build bridges, and I very much look forward to our future collaboration. Thank you very much.
Thank you, Lars. Brilliant remark, much appreciated. So, ladies and gentlemen, I'm reluctant but have to close today's summit now. A big thank you to everybody. The contact reception will be held in the room 703 on 7th floor of this building. So look forward to seeing everybody there. Thank you. Okay, may I invite all the speakers to the stage to have a group picture.
Thank
Yeah, but I think they organize a very teaching the mediation. And because I spent a year in before that, when I get my graduation in China, I didn't know mediation at all. Because the 1 year paradigm really enlightened so that is really impressive. And as a he's now retired, but he is still working about local connection. He also sitting as a president in the city. So anyway, I think although the mediation is a culture for China and Japan, I think that America and United States developed this mechanism as a mechanism for that is very impressive. Yeah, yes. I actually studied in Lebanon in 2009. 2009. Yeah. And I do have some Japanese classmates at that time, but I try to connect it with them, but I don't have the connection too long ago.
Anyway, yes, just explore our mediation network.
Yes. But let me know.
Thank you very much. You too. When you come back, I'm sure it's good.
Thank you.
Going to KO now. Oh, you are? Okay.
这很容易。走吧，咋没去呢？啊，子涵没看着啊？子涵不是说他不去吗？他要回酒店了。啊，你得去。
他已经回去酒店了。
那不知道吧？他可能拉一撇了，这就是多了解能玩，我跟你说，真的。大哥别笑，收东西，就你东西多。
我拍了有个20-30张，
差不多
上吗？这些吃喝
不上，
是吧？
对。
我让他该修，但是不上。
对，不上。不用管，对，都扔，不要了。不要了，咱咋拿去收尔？对，还对呀。回国我都不要，你别说拿收尔。都不要，那个白色笔更不能要，过不了安检，过不了安检。去杭州再